Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for each service.
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
Scratch all that. Oh, that was terrible. I apologize.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Welcome. It's good to have you all here. You thought it was a holiday. It is not. We're here. We're working. Happy Martin Luther King Day to everybody. Welcome. It's good. It's good to be here. Hope you had a great weekend. It was short. I had one day off, but I'm not complaining. Let's see. We have to get things underway pretty quickly. So, Britta Aller, we're going to gift you the internet. Congratulations. You, my friend, are the winner, or shall we say the loser, because we're going to send it to internet ownership. Everything IP related worldwide is now under your responsibility. We'll be calling you. We'll be texting you. If there's a problem, expect to hear from us. If you could just get it all squared away nicely for us, that would be absolutely wonderful, as I try to type in my password without showing everybody what it is. Oh, you can't see it. That's good. Great. Britta, you're going to do fabulous. You'll do fine. You'll do just wonderful. Don't worry about it. We have birthdays today as well, all before we jump into court for another vacation day, a working vacation day for this sequestered jury in the Tennessee versus Chen case. I need my notes pad up here. That'd be useful. Bingo. There we go. All right. I think I got tons of sleep, but we'll see as the day goes on. I might catch a nap now and then. All right, we have just a little bit to say. Let's see. Well, first of all, crazy weather in the United States. Absolutely crazy weather. They're talking about snow in Florida, in parts of Texas, down near Houston, the southern parts of the states. Along the Gulf Coast. It's crazy. It's crazy. And I'm going to blame Weather Watch for that because he's a weatherman. I think he ordered some custom weather for his birthday, which is today. Happy birthday to Thomas, our friend Weather Watch, as we know him on the channel here. Also, we have Stephanie, Genuine Heidi. I think it's Heidi. And Patches all celebrating their birthday. So we're going to sing to them. What I need everyone to do is stand up, take a deep breath, shoulders back.
Happy birthday. You look good.
Thank you, Judge Fleischer. I appreciate that. Shoulders back, take a deep breath, project to the back of the room, blend your voice with your neighbors, warm up with me if you will. La 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 la. All right, here we go. My chair's, there we go, it's stuck on something, like a cable. Happy birthday to you. Happy birthday to you. Happy birthday. Weather Watch, Stephanie, Genuine Heidi, and Patches. Happy birthday to you. To all those who are celebrating their special day today, especially Weather Watch, Stephanie, Genuine Heidi, and Patches, we hope you have the best of birthdays today. Every day is special, but today is your day. The privilege and pleasure is ours for letting us celebrate with you. I realize there are a million people you could be with and a million places you could have been, but you're here with us. The privilege and pleasure is ours. Hopefully we make your day a little more specialer today. And help yourself to free pancakes at Denny's, Waffle House, IHOP, Village Inn, Tammy Dunlap's house. Or I'm pretty sure if you go to Thomas's house, even though it's his birthday, he might make you some smoked pancakes. I think that's a thing. I think you can smoke pancakes. If not, he'll find out. So, happy birthday to all those who are celebrating. Absolutely wonderful. Oh, we've got a late one for Wyatt. Let's see if we can. We'll sing a little a cappella version for Wyatt as a late ad. Here we go. Everyone, places again. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Wyatt. Happy birthday to you. There we go. Got Wyatt in there as well. Wyatt, all those same best wishes apply to you as well, including the free pancakes deal. Oh, yeah, let's see. Colleen says fresh eggs and homemade sourdough toast here if you'd like. Come on over. Invitation for all the birthday people. Wyatt, you heard her. You heard her. Head on over and then go pet the horses while you're there. That would be awesome. Getting drums ready, says Tish. I'm setting up my air drums right now. Everyone, make sure you find your air drumsticks. Here we go. I need to move the mic for this one. Beautiful. Absolutely beautiful. Thank you, one and all. Have yourselves a wonderful birthday. If there's anything we could do to make it better, please let us know. So, thank you. All right, we are beginning day 7 of the Tennessee versus Chen trial, and we're just waiting for, of course, court to begin, which it should be this morning sometime. So get my phone ready in case we need it. Need that plugged in and this plugged in. Let's see. Britta says 17 degrees. 17 degrees, man. That's cold. It's cold. See, do people who don't work for the government work today? Is that a thing? Everyone else works? Megan, there are a lot of businesses that do work on Martin Luther King Day. The federal government employees generally get it off, although there are some, I think, that work. Like law enforcement has to work. And so I think on the federal side, law enforcement works as well. Maybe they just get time and a half or something. Let's see. Try negative 17 Celsius, says Toxic Orchid. I heard it was negative. Well, I only knew about, I watched a couple of weather reports. I watched some of Ryan Holyall. I watched some of Max Velocity. And I was hearing something about negative 50 wind chills up in Montana. In Indiana, wind chills negative 10. Medical is working. They always work. They never take a day off. Bunch of overachievers. Sorry, Amber. Necessary in employees. We love it. My dog is peeing ice cubes, says Nanny Goat. It's freezing out here. It's freezing. Yeah, I hope everyone please stay warm. This is the type of weather that something goes wrong, it can be life threatening. So please reach out to your neighbors, check on everybody, family, friends. Let's make sure everyone stays cozy and warm, because if something as simple as a power outage can suddenly change this cold weather from something that's a bit inconvenient to something that's life threatening. So please. Be that person that reaches out and finds out if anybody needs help. AC's Wildflower, this is the last 9 months. I'm celebrating until my kids start having kids. Hey, that's awesome. Congratulations on 9 months. I think I missed a couple other messages in here. Let me take a peek back into the history. Oh, Shadow, member for 6 months, says, hi, wonderful 6 months. Thank you, everyone. Shadow, thank you. Appreciate that. And Selena K also just gifted 5 memberships. Thank you, Selena, for kicking off this morning with a bang that way, with some gifts for the newbies. All right. Let's see. 42 is cold in Central Florida. What? I'm curious. I realize I mention this every time it gets cold in Florida, but what's the temperature at which iguanas start falling out of the trees? Iguanas being cold-blooded, and they just can't function when it gets cold. They literally lose their grip and just fall out of the tree. It rains iguanas. Is that happening now? Oh, we got a Mo raid first thing in the morning? Thank you for the Mo raid. Welcome, Raiders. Come on in. Oh, the iguanas are falling, said Ali. They're falling. At 32, right at freezing. I know they're comfortable at 80. Like below 80, they get less comfortable. 7 feet of snow in PA, still coming down. That's a lot. Okay, let's get ready to go to court because the judge is showing up. We have to show up. We're all here for it. Oh, he grabs his mic.
Josh or Amanda here. Either one.
He says Josh or Amanda, or Josh and Amanda here. He says I haven't seen them. Who are Josh and Amanda? Who's Josh and Amanda? Oh, that's Defense. Joshua Weiss and Amanda Morrison. Defense is missing. I don't know them by their first name. Apparently the judge does. Luca says 14 months. Thanks to this awesome community and our wonderful host, RA. Thank you. I was reading PA for some reason. No, I'm RA. I appreciate that. Thank you very much, Luca. Andrew JS, a member for 9 months. Hi from Perth, Australia, on a very hot night here, 32 degrees Celsius at 1:05 p.m. Andrew, just about everybody in the U.S. would exchange that with you. It is frigid, as always. We have winter when you have summer, and it's crazy backwards that way. But it's also night when it's day, so you guys are complete opposite from us. Stephanie gifted a membership this morning as well. Thank you. Let's see, we're looking for the Defense. They're sort of necessary because the state has rested. They rested Saturday morning. Yes, we were here Saturday. If you missed it, we did a full day on Saturday as well. So the state rested and Defense took over. Defense, in their case, if we just recap a little bit of where we're at with that. Let's see. Day 6, the state rested. Defense made 2 motions. Obviously, the judgment of acquittal. They wanted the JOA, where the judge comes in and says, "You're right. The state hasn't proved anything. The case dismissed." Didn't happen. Obviously, the judge has to look at that motion. Even though the defense makes the motion, he looks at it in the light most favorable to the state, and that's by law. So if the state presented any evidence that might be construed by the jury to support those different elements of the charge, he says it has to go to the jury, and he ruled that they had done all that. They also had a motion to allow back in Dr. Lewis, which was struck down. Judge says, nope, I'm still not going to let him in. Then they called Courtney Brewer up on the stand. Courtney Brewer was a neighbor of Chen, and she woke up and heard a scream, a woman's voice screaming, and she heard running, and she heard like doors and assorted sounds. She heard a garbage disposal and TV come on, lots of different noises, and then she went back to bed. And she didn't call 911. She was the downstairs neighbor that happened above her, but she heard running from the bedroom towards the door. And that's a problem because Defense says it started in the front and ran back to the bedroom. So it didn't match Defense story from the opening. Talking about the iguanas in Florida, they slow down. You can pick up lizards by hand. To be fair, that only happens in South Florida. I'm in North Florida and we don't have iguanas fall out of trees. Do you have iguanas in North Florida? Or are they just a Southern Florida thing? So that was the first witness from the defense, was the neighbor. Second witness, this was a complete surprise to the witness. He literally did not know he was going to be called to testify for the defense until he heard his name in court. Good thing he was there because he was not subpoenaed by the defense. And that was Travis Pace. Travis Pace is the victim's dad, Jasmine's dad. So he gets up there. He's bundled up in his sweater. Had no idea he was going to be there. He's like, I guess I get up, and he gets up there and he testified about a lot of what happened physically when the family went to the apartment. By the family, I'm talking about Jasmine's mom and dad, who were divorced, but they share a daughter, and they're both concerned about their daughter, and so they were together trying to find out if she was in the apartment. The efforts they went to locate her, to find out which apartment it was Chase and Chen's, then to get into the apartment after there was no answer at the door. The problem is, Katrina, her mom, says, I was behind I was behind Travis Pace, and he used a credit card to open the door, to jimmy the little handle and open the door. Travis says, I just I lifted up on that door until it just opened, and I forced it open, and then I unlocked it on the inside. No credit card was used. So they had a little different understanding of how they got in. It makes sense. Katrina couldn't see, really. But the spice in that moment was when Travis basically was asked questions by the defense about whether Katrina was a truthful person, whether she had a reputation for lying, or people just know that she exaggerates or something like that. And he would not take that bait and double down on that and wouldn't talk bad against her. All right. Broken Baker, who is Jimmy? Broken Baker's like, I've been watching the trial. Jimmy's a new name. It's a sort of a slang term for forcing the door open with a device other than a key. That's what it is. Broken Baker, welcome. Thanks for the raids throughout this trial. We've had several from you, and I appreciate that. While we were waiting for court to begin, I have to tell you, I am going to be filming a collaboration tomorrow.
Bring the jury.
And we start at 6, and it's a hard start time. So if court doesn't get over early tomorrow, we're going to take a little bit off and catch up the next morning. So we'll pause and catch up the next morning because I need to be ready for that. And that'll be fun. So Carrie C. subscribed this morning. Thank you very much, Carrie. Welcome. Welcome. Let's see. It was a joke. Okay. I can't. There's no sarcasm font on the internet, at least not in chat here. Winnaboo, member for 11 months. We're just one short of that next color change. Good morning, everyone celebrating today. Don't usually chat, but do enjoy lurking. Best channel of the mods and fam. Love fam. Lots of fun here. I live here now. Thank you. Welcome. Let's see. Lynn Keeble, member for 1 month. Look at that. You've got a light blue courthouse. That is awesome. Thank you very much for your support of the channel as well. Makes it all possible. Jessica, it's going to snow in Houston tomorrow. Yeah, you don't normally hear those two words together, but they might not just snow. There are parts of Texas that might get a lot of snow, like inches and inches of snow. It's going to be crazy. Snow in New Orleans. Man. Make sure you get the sound bites. Cut, throw, done from the hearing we watched. I have not grabbed those yet. I need to do that. Let's see. Bring the defense. They need a new alarm clock. Yeah. I think it's sort of funny. I wonder what they're doing. Every time there's a delay in the morning, I'm always like, is this the day he just takes a plea deal? But why in the world would you go this far into the case before you take a plea deal? Maybe it's because they aren't able to get all their witnesses in they wanted. We talked about Courtney and Travis. There was a third witness, and that was an expert witness. There was a huge battle before this witness in just getting him certified as an expert in the trial. And he wanted to be certified in certain areas and go into many different areas as both the crime scene blood splatter analysis. Everyone's sending pictures. Look, who's that bundled up in their winter coat? Is that Mr. Moyles? Everyone's got their winter clothes on. They're freezing. I think I see a scarf in there. Yep. Okay, so we got Mr. Weiss in the winter coat and Amanda Morrison in the winter coat. They just came in from the parking lot, I guess. A little chilly, a little cold. It's time to bring in Mr. Chen. They're late. They're 15 minutes late walking into court. Of course, it's cold everywhere, so let's give them a little break. It's cold, says Melissa. It's freezing. Them making a deal is like Netflix canceling after season 3 on a cliffhanger. Who would do that? They wouldn't. Yeah, of course they would. Just bundle up by the fireplace. I think I counted one time. 1, 2, 3, 4, 5, 6, 7, 8. I have 8 fireplaces in my house. I have never used any of them because all of them are coal-burning fireplaces, which are designed to be very shallow. I don't think you could fit a chunk of wood in there. They're meant to have little bits of coal, and I'm scared to light them because I have no idea if the chimney goes all the way up or if it's just straight raccoon nests all the way up my chimney. So too cheap to hire a chimney sweep, and so if we lose power, we're just going to be cold. But I do have a generator, so I can at least get through that way. Gas fireplace, all I do is flip a switch. It's a lot of fireplaces. Kathy, it's a lot of places for cold air to come into the house. That's what we have. My house was built in 1915. It was a beautiful mansion back in the day. Now it's a money pit that I throw money into to try to just keep it up around my ears. How's the bathroom progress? 2 boards pulled out, 2 boards put in. That's all we did over the weekend. But they were the boards that supplement the main 4x4 beam. And so now we're ready to build the furring wall, I think it's called. A furring wall, put the plumbing in, and put the floor in. That's where we're at. And electrical. I think you're supposed to like draw out electrical and like have like a plan for where you want switches and things. I was just going to pull cable and call it good, but I have no plans. Nosy Rosie, no. The little RAs do things like throw hard objects in the house and break panes of hand-blown glass out of the, 15-panel glass 8-foot doors. So yeah, that's what they do. We have them break those little windows for us, which are irreplaceable. And our chandeliers, they're 1, 2. I've got a tiny chandelier in here. 1, 2, 3, 4 chandeliers downstairs, 3 upstairs, and I think they're breaking all of them. I mean, like, we're talking crystal old chandeliers, beautiful. They're all ready to just be scrapped. Money Pit's my all-time favorite. It's a funny movie. It's a funny movie until it's your life, and then it's not very fun. Yes, it is. Almost on the button. 3,000 square feet. But every room is 14 by 14. And we have like 11-foot ceilings downstairs, 9-foot ceilings upstairs. So you got a lot of head space, but all the rooms are basically square, except for the dining room. That's larger. Sounds pretty. It is pretty. This house has a lot of character. Fell in love with it. Unfortunately, it was in our price range because it needed so many repairs. And we've only done about half of the ones that needed desperately. And a hole in the kitchen ceiling. Our hole is in the upstairs bedroom. They cut like a 4-foot by 4-foot hole that they could push an air handler up into the ceiling with. And then they just took some foam, like the foam they put on the outside of the house for insulation. They just screwed that over the hole and called it good. Can you take pieces and make a new chandelier? Yes, although the middle piece is broken. The little crystal ball on the bottom, that's still there. But the little shroud that goes over it, the little reverse ashtray that sort of it hangs from, that part got broken. But if you do make a new chandelier from it, you'll want to redo the wiring because there's terrible wiring. All right, still waiting for the defense to get settled. How is your house not haunted unless the little RA count is haunted? I've seen a few things here that I can't explain, but hasn't bothered me at all. I hear voices too. That happens anywhere. Yes, do have a new desk. It's a standing desk, which I'm sitting at right now on a high stool. But it's a new desk and it has lights like this. See that? I'm liking it. That was my Christmas present to myself. Mr. Fix-It, we've had a lot of people express interest in items that were in this house originally that we're trying to get rid of, like the Frank Lloyd Wright inspired stained glass window, things like that literally needs to be redone. None of the glass is broken, but you can see through gaps and stuff to the outside. Our house is like a sieve as far as blocking the wind. I did buy this house without my wife having ever seen it. And that was, she told me that's the last time I will be choosing the house. The company was great. It took about 2 weeks to work out the deal, but they did send me replacement lights. The funny thing about the lights, let me show you one more time while we're waiting for court. The funny thing about these lights, this side of the original lights would just like flash and the other side would not. And it would not cycle through. Like I'm supposed to be able to choose like a whole bunch of different designs and colors, and you know, I can make it do funky things like if I get there eventually.
Is it a separate network?
The DA has their own separate private network, as it should. The defense bar is what we have to use the public Wi-Fi for the court.
Seriously?
My computer, because of the security protocols that I have to have.
The judge is making a call. Hang on, my phone's ringing.
Other people can connect to the network. It slows down and it drops off after about an hour. Other than for General Moyle. General Moyle works perfectly.
It is slower, no matter what you do. It is slower, but I think that's something county IT should work on for.
I think we can make that happen. We can log it on to Mr. Wise. It's got HC Gets, we've got HC Courts. HC Gets.
They're giving out the Wi-Fi name and password right now. Anyway, the company, the lights were supposed to do fancy things. They weren't. I contacted them. It took a while to work out the resolution.
It's not even a funding problem. There's enough members of the defense bar that we would gladly pay for it.
There you go.
We can make that happen. There is I'm on HC Courts. That's separate. We can certainly share that one out.
Just put it in chat for the rest of us, Judge. Anyway, the fix for the new lights, instead of sending us just new lights, they sent an entirely new desk from the top up. So no legs, but entirely new desk. So I now have 2 desk tops and 1 working set of lights. That was their choice. I just wanted the lights, and they said, oh, we don't have some. We'll send you a whole desktop. Yes, bank holiday in the USA. Courts were closed normally, but we have a sequestered jury, which means they can't go home, and so the judge is allowing them, if they wanted to work. He said, if there's one of you who does not want to work on Martin Luther King Day, we'll take the day off. And they all said, we're in for it. So we're here. They did a good job, although it took 2 weeks of fighting, literally probably 18 emails back and forth. And one of them had to be with Amazon A to Z before they offered to fix it. I don't have to rebuild the desk. That's the thing. I've got a flat pack, an entire desk with no legs. All the parts, pieces, everything. I can build a desktop just no legs on it, because it comes in 2 packs. One is the legs and the motors and everything for the bottom, all the metal. And the top is all the wood and the shelving and the lights. I have the top piece again. So don't know what to do with that. Can you sell a desk without legs? I guess somebody, a woodworker would be able to design their own. But.
Let me know.
Are we going to do a jury instruction conference?
We will. Whenever the parties have a better idea of when the proof may be believed or get close to that. So, once we get close to that, we'll certainly have that conference.
So we're playing with the sound on and off, but
Yes, sir.
as always, the first thing to do is approach. when we know better when the defense is going to rest, they'll start getting, scheduling the jury charge conference where they talk about the instructions the jury's going to get, and we might know at the end of today or maybe tomorrow morning a better idea of when defense is going to be done. I bet the defense is close to resting. Will be interesting to see. No indication yet as to whether Mr. Chen is going to testify. So I would say he is not. Usually when they are going to testify, they do it fairly early on, or they're the only person to testify. But they've got other defenses to put forward, apparently. So why risk it and get him on the stand, which could, be terrible. My son is addicted to his VR headset he got for Christmas. I've been looking at those. I've got a son who absolutely loves watching Beat Saber, which is I think you've got like two lightsabers, and you're playing rhythms by hitting different floating colored pads in the air. So it's like air drums with lightsabers. And that's probably the best thing. He loves it, and I'd love to get that for him, but I just can't justify the expense. Cody, you were doing a 24-hour iRacing? That sounds awesome. I wish I watched you race. I like watching those. Send the burner phone a link to your, if you got a channel. I'd love to see that. Let me see if I can do some magic on the audio here, because it's a little bit quiet this morning. I can buy replacement legs for the desk. It is an L-shaped desk. Mine's designed to lift 330 pounds. That's desk and all the stuff on it. And since I have like 5 computers on it, and some switchers, and I rest my arms as well, that works for me. But the legs for the desk are the entire cost. The top is nearly free. The legs are $350.
I mean, the point here, exactly what the defense was going to hit on. So we've submitted a motion to include voluntary intoxication and self-defense.
Your Honor, there will be a motion from the state, but I don't believe it's proper until the defense rests.
Okay.
They have a motion for voluntary intoxication, even without Dr. Lewis as the witness.
It's not proper until the defense rests, so I apologize.
No policy necessary. I'm thinking about things for a while, but we'll do it in the right order.
The judge wanted to hear what the state's response would be, and they said it's not right for us to do it until after the defense rests. Let them get everything out before the state has to respond. Otherwise, they'll get more chances to shape their argument and change it. That voluntary intoxication they're talking about, involuntary intoxication is a defense. That basically means someone drugged me. Yeah, they forced alcohol down my throat. They injected me with some mind-altering substance. That would be involuntary intoxication. Voluntary intoxication is like, I got drunk, and then I did something stupid. Now, that is not normally a defense for a crime in most states. But I mean, there's some states that is a defense, but in Tennessee, it is for limited purposes. There are limited situations where voluntary intoxication could be used as a defense. In this particular case, it is one of them, because voluntary intoxication, if believed, if the jury says yes, we find that that's the case, it can remove the ability for the defendant to have premeditation. Like, I didn't have the capacity to premeditate my actions because I was voluntarily intoxicated. That's what they're going for. And with them saying they're going to file a motion on that, I do wonder what witnesses they would have. I mean, you almost need Mr. Chen to get up and testify to it himself. She had no alcohol in her system, but it's him. It's him they're worried about. They're only see, they don't they know that she's dead. They've admitted that he killed her. That is something the defense has already waved the white flag on and surrendered and announced at the beginning of the trial. But now all they have left is to be able to save Mr. Chen from life without parole, and they can do that if the jury believes that there was voluntary intoxication, because that makes it impossible for him to have premeditation. People usually drink together. They do. Elizabeth, they have said it was self-defense. You've got an issue here. You've got an issue. You have an almost uninjured Mr. Chen, and you have 60 stab wounds on the victim. In addition to that, you have 60 stab wounds on the victim in an area that would be exposed to attack had the shackles been present on her at the time, which makes it really hard to say I had to defend myself. If she's coming at him, why are all the attacks on her back and on her neck and on her side? Why is there no attacks on the front? Why? You'd think that an attacker would have to defend themselves against an oncoming attack. Did she come at him with her back? It's going to be a tough one to sell, that self-defense story. Who's going to testify that he was intoxicated? Well, we already got the previous doctor, Johnny Lawrence, not doctor, but expert, who visited the crime scene twice to testify that there were, in fact, wine bottles where the cork had been removed and then put back in. As far as how much liquid was gone, he wasn't able to testify. I think there were at least a couple. Apparently there was like a little wine collection there, but he wasn't too drunk to clean up. That's a good point, Mr. Upper Torso. If they change defenses, Elizabeth, the jury's already heard their story once. And they can change. I mean, what they heard at the beginning is not evidence. What the lawyer said is not evidence, which is why, as far as the jury's concerned, the defendant has gone into court and said, I'm not guilty. It wasn't me. The state has to prove all the elements because he did plead not guilty in front of the jury. So the state is proving every element of the charge. And he now has to... If he presents that defense, that it was self-defense, the state would then have to prove that it was not self-defense, which I think they've probably already done. We're just throwing things at the wall today to see what sticks. There's no toxicology report on him, no real proof he was intoxicated at the time of the murder. Shore Life, he wasn't taken into custody until days later. So... You can do toxicology on somebody when they're arrested, but it won't tell you historically what happens in his bloodstream. There's no proof he was drunk. Why isn't this a death penalty case? Unnamed True Crime Channel. Tennessee does have death penalty, but not every first-degree murder is prosecuted with that as the end goal. Generally, when you have a case where it's difficult to prove some of the key elements of the crime, especially those involving premeditation, you'll find that they go with life without parole instead of death penalty. It's a higher standard, it's a higher hurdle for the jury to get to, knowing it's a death penalty case, to find him guilty if there are some question marks as to how it happened. Or some aspects of how it happened. If they've got a slam dunk case that was all on video, with him, making a video and posting to TikTok or Instagram or something, his intention to go and waylay somebody and murder them, that's probably death penalty. All right, here we go. Defense is up. Oh my goodness! I thought he was taking the stand. It's the colloquy. It's the colloquy.
I do.
All right, Jason. You have the choice today of whether to testify or not testify. is after talking with your attorney and going through your own thoughts, what is your decision of whether or not you want to testify?
Not to testify.
You choose not to testify.
Yes, sir.
Ms. Weiss, want to talk a little about how you talked about it with him and gone over with him?
Not to testify,
Yes,
you
so,
said.
Jason, we've met a number of times. We've talked about what your testimony would be, and you understand that even though you might have an opportunity to say your piece, that you would be subject to cross-examination. And I've explained to you that the cross-examination would probably be very intense and relentless. And by subjecting yourself to that, you can change the status of your case. You can make it worse. You can make it better. That's the thing about testifying. You don't know how it's going to go. But it's important that you understand that you have an absolute right under the Fifth Amendment to testify. In your case, no one can prevent you. The judge, the court, no one, is certainly not me, is stopping you from testifying. This has to be a personal choice. On the other hand, if you want to testify, there's nothing this court would stop you from doing that. So whatever it is that your decision is, it is a personal decision that only you can make. Have you had enough time to consult with me, talk about whether or not, go over the benefits and detriments of testifying?
Yes.
Jen, congratulations.
Are you deciding not to testify on your own volition?
Yes.
And that's what your personal decision is?
Yes.
Jason, also, Tennessee law requires that the jury fix any fine greater than $50. You have the ability to waive that right and allow this court, Judge Patterson, to decide the amount of any fine, if any. We've gone over the benefits of allowing the court to decide versus the jury to decide. We've given you these recommendations. Do you want to waive your right to have the jury assess fines in this case?
Yes.
So the judge will assess fines if there's a conviction. That's a Tennessee-specific thing.
Chen, Mr. Weiss is a thorough attorney. I know he's gone over this with you before. He's obviously went over with you just then at the podium. I just need to make sure to understand everything that you have obviously consulted with Mr. Weiss, Ms. Morrison, that it is your constitutional right to testify or not testify. If you were to testify, you would be cross-examined by the state. However, while your attorneys can give you advice about their opinion, whether it's a good thing to testify or not testify, ultimately that is your decision. And so your attorney asked you this, but now I'm asking. With all that being said, it being your call and your constitutional right to testify or not testify, what is your decision?
Not to testify.
So you executed this waiver affirming that.
Yes, sir.
And as Mr. Weiss indicated that the jury does get to set fines over $50, most people waive that. And I see you signed a waiver here for having the jury assess the fine. You're allowing the court to set that fine, if any, correct?
Yes, sir.
Thank you, ma'am. Counsel.
His chair's lowered to create the illusion that he's shorter. Possibly. See when they sit down.
All right, so the procedure, what we'll do is we'll bring the jury in. I'll ask the defense for any more proof.
Maybe.
From the defense, I'll ask the state if there's any rebuttal proof. And if the answers are what I expect, we'll send the jury out again and have our comments. Okay?
Yes, sir.
All right, bring the jury, please.
So now the jury will be brought in. They don't get to hear that. They will be instructed prior to jury deliberation that they cannot place any weight. See, now he stands up, so the jury sees him, how tall he is anyway. They can't place any weight on whether or not he chooses to testify. They can't hold that against him. static is terrible.
Please be seated. Good morning, jurors. Hope you had an enjoyable day of R&R yesterday as much as you can enjoy it. Was it relaxing for you? I hope. Didn't have too much fun Saturday night, I hope. No? Okay. All right. We'll start as always, just asking to make sure that you make sure everyone was able to abide by the court's admonition not to be exposed to media and not to talk about the case among yourselves. Along with the other things the court admonished. Is that correct? If so, just nod your head. Okay, the record reflects everyone is nodding their head. Okay. All right, Mr. Weiss. Any more witnesses for the defense?
The defense rests.
State calling your rebuttal witnesses.
They rested.
No, Your Honor.
Ladies
You
and
called
gentlemen,
it.
You've heard all the proof you're going to hear in this case.
You called it, John
That
Malama.
means that there are some matters we do need to take up outside of your presence. It may take a little bit of time. I'm not sure how long this will go.
Wow.
However, once that is settled, you'll be brought back in. The court will read to you jury instructions, the thick packet. You don't have to write down what I say. Just pay attention because you'll have a copy to refer to later. There'll be points that both sides want to point out. Once I read the majority of the jury instructions, both sides will have a chance to do their closing statements. The state will close first. The defense will do a closing argument, and if the state wishes, they have a chance to do a rebuttal argument. At that point, we'll finish the jury instructions. We'll pick the alternates, and there's a little special way we'll do that. And the 12 of you who are selected to be the actual jury in this case will go back to jury to deliberate. So that's what's ahead of you. Again, I'm not sure how long it'll be if we bring you back out. Maybe a short amount of time, may not be. Be patient with us, and we'll get you back out as soon as we can. That makes it easier.
All right, now the jury leaves again. We'll need to cover the jury questions. There are some motions that need to be made. There's going to be a response. The defense has filed a motion today about voluntary intoxication, submitting that as officially as a defense with very little evidence to support it. Just the presence of wine bottles in the kitchen with some that the cork had been opened and replaced in. That is quite weak. It's a quite weak argument, evidence-wise. So the state will have an opportunity to respond to that motion now that the defense is rested.
If you want to make a renewed motion for judgment of acquittal, you can at the close of your brief as well. If you wish to. If there's anything.
Yes, Your Honor. Pursuant to Rule 29.
Please be seated.
Pursuant to Rule 29 of Tennessee Rules of Criminal Procedure, the defendant moves for judgment of acquittal, renewing this for the same reasons in the motion the defense made after the state rested.
Okay. I don't believe the witnesses called by the defense tipped the balance to the degree where, looking at the evidence in the light most favorable to the state, that any rational finder of fact could not find the elements of the offense. Again, this isn't a finding of guilt beyond a reasonable doubt. It's simply a finding that allows the case to be sent to the jury. So, Mr. Weiss, your motion is respectfully denied.
Yes, Your Honor.
Okay, I see a motion to exclude voluntary manslaughter.
Yes, Your Honor. Would you like to say to argue it at this time?
Is it not a lesser?
It is a lesser if the court finds that evidence exists which could cause a reasonable juror, based on the proof presented. We would start, Judge, with Tennessee Code Annotated 40-18-110, which specifically reads that the trial judge shall not instruct the jury as to any lesser included offense unless the judge determines that the record contains any evidence which reasonable minds could accept as the lesser included offense. Further, the state has included many cases of first-degree premeditated murder in which the trial courts excluded as a lesser included offense voluntary manslaughter. The case law is very, very clear on this, Judge. A murder will only be reduced to voluntary manslaughter when the provocation was caused by the victim. Adequate provocation is an element of voluntary manslaughter, as is state of passion. The defense has put on zero proof of state of passion, or more importantly, adequate provocation by the victim. Pieces of glass of the nature that the jury saw underneath the futon are not any type of proof of adequate provocation. A witness who heard a female scream in, quote, distress 7 minutes before the location was sent to Katrina Bean is not evidence of adequate provocation. The jury instructions simply, according to the law, should not be given to this jury. They have no evidence, no proof whatsoever of adequate provocation. The cases are interesting. The cases are similar. The courts in each case, when there was some type of argument, in fact, Judge, the cases, in all cases, there is proof of arguments. There is proof of passion, even, in some of our cases. But the courts found that adequate provocation by the victim is required and was not found in cases with actual arguments. There has been no proof in this case of an argument. There has been zero proof of even an argument in this case. A much lower threshold than what courts have found in the cases that the state cites. And the reason this was not proper, Judge, is because the state had to be brought before today, is because the state had to wait for the defense to rest. The state didn't.
I get it. I hope you know I was just trying to be lighthearted.
Sure. Well, but procedurally, I hope that all parties understand why this couldn't be raised. But it's the law. And so it can be a lesser included, as the court asked, but it is not a right of the defendant to have this instruction given by the court. We would ask that it be excluded
They're going
based
for
on
all or nothing.
the law. Judge.
This is impressive.
While you're here, I'll tell you here for you, Mr. Weiss, but I can tell you that the threshold to charge an offense, the jury instruction, is less than a preponderance. It's not much at all. And like the motion earlier about the judgment acquittal, this one is taken in favor, like most favorable to the defendant. What I recall, and I'll let Mr. Weiss, fill in the gaps if I miss anything. Clearly, they were in a relationship, which doesn't by itself, mean adequate provocation. But the fact that there was some type of fight, whether the fight was, as the state's theory is, Mr. Chen starting it, and where the victim was basically not contributing to it at all, there was some type of fight between two people who were in a domestic relationship of some kind. And if I recall Dr. Cogswell's testimony when Mr. Weiss was cross-examining him, the testimony about the knife being held in the same position, I think Dr. Cogswell indicated that it would have come very fast, without much movement, on the part of the defendant. And I believe the language that Mr. Weiss got out of him was either heat of passion or heat of excitement. So that's what I would recall. If you want to respond to that, you can now. If you want to wait for Mr. Weiss to fleshes out, you can.
Well, heat of passion is not mutually exclusive with premeditation. Most first-degree murders involve passion to some extent, right? And so, in our cases cite this. I don't believe that even if you give Mr. Weiss the benefit of the doubt and say there was proof of an argument, according to Tennessee case law, that's not enough for adequate provocation. There was also proof introduced that there was chasing from the bedroom of the apartment to the front door. I think that could negate any type of argument that it was a heat of passion where there was an argument going on. I think that could indicate to a reasonable juror that she was trying to run away. Right? And so I don't believe the proof on the record supports any type of adequate provocation, Judge. Even Dr. Cogswell's testimony. Often in first-degree cases, gunshots are fired back to back to back to back. I don't think it matters that the stabs happen. If the stabs happen 1 second after 1 second, you still have 60 seconds of stab wounds. So respectfully, the state will always trust the sound discretion of the court, but respectfully, I believe that the law supports no instruction on voluntary manslaughter.
Thank you. Mr. Weiss.
Firstly, Your Honor, this looks like a well-written motion, and it's been written for some time. If the court knows my modus operandi, I would love to be able to go through this with a fine-tooth comb and shepherdize each case and look at any subsequent case law on it, and also search for case law that would provide perhaps the opposite conclusion if it existed. I doubt I have time.
Well, so this, of course, I can make a ruling on this after you argue. You don't have to sit down and after looking at this and trusting that the whole case, the essence of the case is in the state's motion. I'd love to hear your argument, but we'll take a break and give you some time to look at it if you wish.
Even if I can't do an adequate job in 5 or 10 minutes.
I'm saying if you want to take, again, this is important enough where if we're closing today, I want to give you not as much time as possible. I want to give you as much time as possible under the circumstances. So we could break till about 10:30, give you a chance to look at some of these cases. If you get into it and decide you need some more time, we certainly will.
Yes, Your Honor. Would the state be courteous enough to send me a digital copy of this?
Of course. Sure.
Yeah, I appreciate it.
We'll send it to you in this morning.
Thank you.
Okay, so the court will be in recess till 10:30, and otherwise you get your answers sooner or later. Please let me know.
All right, with that, let me just tell you what just happened, because we've had 2 surprises. We've had 2 surprises today. Let me.
Do the other motion for jury instructions from the defendant later or at this time as well?
We'll do it that time. We'll take it one step at a time. Consider additional instructions the state wishes.
Oh, no, Your Honor. The defense filed a motion for additional instructions.
Okay, I'll look at that.
Okay, thank you, Judge.
I can copy it.
Okay, this is why this is a big deal. 2 big surprises today. First of all, the defense rested. Before they rested, they said they filed a motion of voluntary intoxication, which would basically say we're asserting the defense that he was drunk at the time and thus could not form the necessary, did not have the capacity to form the necessary premeditation, to have premeditation in this attack. That would be given as an instruction. It would be worked into possibly the verdict form if the jury believes that was the case. That's one. Then we have the defense renews the motion for the judgment of acquittal, which is expected. It's a formality. It was summarily denied, and almost in the same breath that the judge offered to have them renew it. So that's going nowhere. He says there's plenty of evidence. This is going to the jury. Then defense rests. The state gets up and immediately files a motion to exclude involuntary manslaughter as a lesser included. This is what the defense is hoping to get him convicted of. They want their client convicted of involuntary manslaughter. They know he's going to be convicted of one thing or another. If they take involuntary manslaughter off the table, that's the next rung down. Okay, you've got murder 1, and the next rung down is involuntary manslaughter. It means that the state is so confident in their case, they're saying, we want you to provide, Judge, the jury with instructions so that you either find him guilty as charged or not guilty. Those are your options. And she cites case law saying in Tennessee, the only time that's appropriate to have involuntary manslaughter on the jury, the verdict forms, is if there was some indication of instigation on the part of the victim. Like if she started the fight, if there was an altercation going on, and she says there's nothing. You've got some broken glass under the futon that could have been there for years. You've got nothing other than that, nothing. But the shoe is on the other foot when the judge has to consider this, just like on the judgment of acquittal, where he had to look at that motion and look at the facts of the case in the light most favorable to the state. Now on this motion the state makes, he has to look at that in the light most favorable to the defense. So if there's anything, a sliver of evidence that could be construed as supporting that there was an altercation and possible instigation on behalf of Jasmine, then he has to rule in favor of the defense. So he'll make that decision here. He's not ready yet. He says, the defense says, I'm blindsided by this. I was surprised. Clearly, you heard him say, this is a little jab. He's like, clearly this is a well-written motion, meaning that they spent some time. They knew this was coming. They didn't warn me. I've been caught off guard. I need more than 15 minutes to read even the case law they've cited to formulate my response. That's why we have now about a half-hour break left. So he can read the case law. He can get down to the brass tacks of what's behind it and offer an intelligent response that addresses the issues that were presented in the motion. Wow. Okay. So already a big day. Looks like we may have closings today. Probably right after lunch. So it might be a lot of breaks. The jury's going to spend a lot of time sitting in the back room because what happens to happen now is not in their presence. All these arguments not in their presence. Any discussion and argument over jury instructions or supplemental instructions of the jury, which it sounds like the defense has asked for some. The state has not, so the state will probably be opposed to whatever the defense has asked for, saying, no, we just think the regular ones apply. That argument will take place outside the presence of the jury. It'll take some time to get those formulated and printed out for the judge to have so everyone has copies. The jury will have copies. Then once they have them, the jury will be brought in and read most of those instructions. Then we go into closings. And closings, the state will have a shot, defense will have a shot, the state will have a closing shot, and then there will be a tiny charge the jurors, and off they go. And then we'll be in verdict watch. So we could very well have a verdict this afternoon. We are on break right now, just for the defense to sort of formulate a response to this, the surprise motion to exclude involuntary manslaughter as a verdict, as a lesser included. It may free me up for the interview tomorrow, which is going to be great. I love that. All right. We have, Carol, maybe I should renew my Westlaw subscription. Just a thought. We have the votes of pretty much, well, they're still coming in. We have votes coming in on how would you vote as a juror. We typically reserve this particular poll until both sides have rested. And now that happened this morning, we have put that out for the first time. I think in this case, we have done some other polls, but this is the first time we've strictly addressed the issue. There are three possible options on this poll. As always, we put not guilty first because there's a presumption of innocence with any defendant, even if they admit their guilt. Not guilty, guilty as charged, or guilty of lesser included. It looks like we're slowing down on the votes here. 648, 654, 651, 657. It's still coming in a little bit. I'll wait till it slows down. It looks like about half of you have voted here. We're at 660, 664 votes, 669. I don't want to close it off right as somebody's like reading the answers and about to click on it, and then it disappears. I'd feel cheated. 677, 678, 676, 681. We'll just give you a minute to finish up that poll, and we'll post the results. See, the jury will have a quick verdict. I'm not convinced that they're going to have a quick verdict. First of all, the jury has been very thorough in every situation, with the questions they're asking, with the details they're looking for, with their requests. They have asked to see the body cam footage. They've asked to see the messages, and they're getting a lot of that back. They're getting hundreds of pages of text messages back there. They may want to really pore over this information just to ensure they're making the right decision because they're not taking it lightly. All right, 719 votes. Oh, now it's down to 714. Now back up to 719. How did that work? How does it go backwards? You guys, somebody withdraw your votes. 722. I'll give it just about 10 more seconds here. We'll end the poll. $725, $726, 5, 4, 3, 2, 1, 0. 732 votes. What we got, the poll results are as follows. I wish I could put them in chat. Let's see. Copy. Let's see if it'll let me paste this. There we go. Guilty as charged, 93%. Guilty of lesser included, 5%. Not guilty, 0%. The poll was complete with 734 votes. As you can see, if you do the math, a couple percentage points disappeared. A couple disappeared. So Yeah, but I can't put it on the screen unless I retype it. That's the only problem. Never seen a trial with a sequestered jury before. This has been very interesting. Artie Bay, we know a couple things about the jury. First of all, they have not been complaining about being sequestered, but they are ready to work. So they worked most of the weekend. They took yesterday off. The court did something yesterday with the jury. They said we have arranged some sort of an outing. I would guess that the court accommodated anyone who wanted to participate in a religious observance of some sort on Sunday. I'm guessing that's what the outing was. I laughed out loud when I saw your face when you stood up and you thought he was going to testify. I was not paying attention. I didn't realize we had the colloquy right then. But that was, it got my heartbeat going. Maybe they went to a football game. Some people would call that a religious observance, Mr. Rubber Torso. It just depends where you worship, in the stadium or in the church. Let's see. I had a whole plan around the trial today to do my nails, work on my book, pick up work clothes. I've only gotten my nails done, says Alice. Alice, thank you very much. What are we waiting here for? Emiel, right now we're waiting for the defense attorney, Mr. Weiss, to read the case law behind the motion that the state just filed. We knew that there were going to be lesser included from the very beginning of this trial. We were under the assumption that there was going to be a lesser included offered. What that means is the jury, when they're deciding if he's guilty, the state has charged him with first-degree murder, the penalty of which, if they find him guilty, is life without parole in prison. But we knew that the jury was going to have an option to find him guilty of something less than that. That would be involuntary manslaughter, meaning, I did kill him, but it wasn't sort of intended. Or that I didn't have, not all the elements of voluntary manslaughter, first-degree murder, were present, particularly premeditation. So if premeditation is gone, it does not meet the elements needed for that first-degree life without parole penalty. So the lesser charge would be involuntary manslaughter. That has been from the get-go what defense wanted. They literally stood up in their opening statements to the jury and said, my client is guilty. He killed her. He's guilty. He's just not guilty of what he's being charged with. It's a different crime. Choose his words at the very beginning, and it was quite impactful. I think Mr. Weiss did a great job with his words. Let's see. He says, Jason Chen is guilty, but he's not guilty of the crime he's charged with. Jason Chen should be found guilty of the crime he did, not the crime he didn't. Which was how they started this case, and this was also a surprise. We've had surprises throughout this case. Never before had he admitted guilt in this. He had always just pled not guilty. So the first witness up, who was Jasmine's mom, literally minutes before she took the stand, she heard for the first time Jason Chen admit through his lawyer that he was in fact guilty of killing her daughter. Selena K gifted a membership. Thank you very much, Selena. I believe death penalty, but I don't count. Go back and look at Cody's face when she turned around from the judge's desk at the beginning. She looked surprised and excited about defense resting. She did. They were quite excited. It sort of explains why the defense was a little late. They were probably having a little powwow outside, thinking, is there anything else we should do? Is this what we want to do? And yeah. Let's see. The defense liked to throw off the parents. Both of them got surprises right before they testified. Amy P., it does take a little while to update. If there's also someone else already in your town, it usually only shows one pin per town or city. You may want to, if that's the case, you may want to submit a pin with a town just outside or near you, just so it differentiates. Like if you live in Houston, you can say, an area just a little bit away. That might work. Let's see. His state does have death penalty. They just did not pursue it in this case. The parents are in court. They don't show the gallery, but Mom has been there and her dad. So Katrina and Travis have been there. They're divorced, and they were divorced, I believe, at the time this happened as well. They've been divorced for like a long time. But they have been present in court. Carolyn W. member for 19 months says, love y'all. Thanks so much for having the best place to watch true crime. Thank you, Carolyn. Thanks for making it the best place to watch true crime. This community is made by you. It wouldn't be the same without you. So thank you, and thanks for 19 months of support. The person from my town has the same last name as me, says Tipsy Tracy. That's awesome. Give us a little bit. If there's nobody in your town, it manually has to be updated. All right. Let's see. His parents are there as well. We were told in a pretrial motion, which I think we watched on here, there was discussion about having an interpreter for the court, and the defense said we need an interpreter, and the court says no, you don't. He speaks English just fine, and they're like, it's not for him, it's for his mom when she testifies. Now there may still be a chance that she testifies in the sentencing phase if there is a lesser included, and if the jury finds for that lesser included. If they find for guilty as charged, I believe it's a mandatory minimum life without parole, and there's no need for a sentencing phase. There's no investigation, pre-sentence screening, and there's none of that. So she may still testify. We may still hear from her through an interpreter if it goes that route. I don't see the prosecutor playing dirty in this one. I think she's pretty well right in the provocation thing. She has been right several times where I think the judge made a mistake, and she's corrected the judge a number of times. She does sort of give the personality that she's the adult in the room, sort of a little bit. She comes across that way, but she's been very, very good and very, very right at everything she's done so far. Why no pre-sentence investigation? If there is only one option for a sentence, there's no need to weigh factors to determine how severe the sentence should be. If the only option the judge is legally allowed to give as a sentence is life without parole, it's done. It's done when the jury says guilty. Attorney Cody is a bulldog. She's really good. She's really good. All right, we have about 20 minutes. Let's see. I don't think we have any. Most courts are not live today, so we don't have a lot of other trials we could jump to during the day to catch up on. I'll have to look and see who's up, but give me a minute to take a peek here. I'm not seeing any alerts from any of my usual haunts. You could show the final iteration of the poster. I'm done with it now, I think. All right, let's do that. Did the link in the description never work? I posted the link to the thumbnail in the description, but it looks like it's not posting correctly, Red Pen. Britt, I am looking at that. We may jump to that tomorrow and play catch up. Tomorrow in Simpsons Court has a good one on the 9 a.m. docket. Is that the gentleman that was pro se? What was his name again? The guy who always has his earbuds in when he goes up to the judge and he always has to take him out. Yes, that's the one. All right, we'll definitely watch that. Next might be the Cochran trial out of West Virginia. We'll have to play catch up on that one. Mr. Magoo. Mr. Magoo is his name. It's not spelled that way, but yes. Kelly Brown, welcome to the gallery. Wonderful to have you here. I probably should have told you this before you joined, but it's a one-way door. You can never leave. You're one of us now. Welcome. It's not the earbud one? I haven't looked into Megan Boswell's. I think that one, well, I think it starts early February, right? Or like February 3rd on Megan Boswell. So we might have some time before that one comes about. Yes, in February. We'll put that on the tentative list and see where we need to send some applications to. It is almost February. Isn't it 20th? We've got like 10 days, right? We've got a third of the month left. Melanie, it depends what's happening in this court. I don't want to miss the spicy argument, especially when we're determining whether or not there's even an option for a lesser included. If there's not a lesser included, he's done for. There's no way the jury is going to get up there and say not guilty when his lawyer got up and said my client killed her. He did it. I think honestly, when I look at this, the judge is going to include that option of the lesser included, just for that reason. I mean, he might as well change his plea at that point. Selena, thank you for bringing Kelly Brown in. See, I tell you, you're among friends, Kelly. That's awesome. How do you find out how long you've been a member? Watched you over a year and love your channel. I think in your YouTube account you can see how long you've been subscribed to places. If you've been gifted a membership or purchased a membership, YouTube will track that, and I can see that every time it renews, or most of the time it renews. But I think you can see it on your end as well. It's the sob sit that threatened the judge. Ooh. That could be a good one to watch. Was Magoo a litigation about rent? I forgot. I think it was actually, Mr. Magoo was interfering with a police officer or something. It was, I think that's what it had to do with. Like he was stopped by a cop and he got all, sob sit with the police officer. When we watch the Cochran trial, be sure to cover the email from the juror before opening statements begin. Oh, wow. Wow. Didn't the judge say that he needed to see what was most favorable for the defense? I do believe they will add the lesser included too. Yes. That means the judge by default weighs anything the defense presents in this argument about that lesser included very heavily in favor of the defense. If there's anything there, he basically has to allow it. Cody put up a good fight on direct and on the follow-through or follow-up with that. Oh, it's Judge Washington? Bummer. Are the defense attorneys private defenders, public defenders, or private attorneys? Tim, I believe if we look at a couple things in this case, Mr. Chen got a lawyer immediately. Like within a couple days, he had a lawyer and he had an expert at the crime scene. I will tell you, that is not a public defender. A public defender, if they want to have an expert hired on and paid for, because it is tax dollars that are making that expense, they have to file a motion with the court. The court has to hold a hearing. They have to, talk about the prices and, approve all the numbers. And then the court will say, yes, you can hire it. It doesn't happen that quick. You don't get immediately, just days later, a defense attorney. So I would say that these were public defenders, but he then was declared indigent. So he had some money, has run out of money, and he still has the same team. So now I think I don't know exactly how it worked out, but I think it started out as a private hire. Can they find him guilty of both, or is it one or the other? Martha, I'll use the example of the candy bars. This is a fun example, if I can get it right. If you have a candy bar that is made of this wonderful chewy nougat wrapped in chocolate, you have a Three Musketeers. If you add Milky Way, if you add the Milky Way ingredients, that's the caramel, then you're up to the Milky Way level. If you then add peanuts, you're up to the Snickers level. So you could say that Three Musketeers and a Milky Way are lesser includeds of the Snickers. So if you have every element or every ingredient of the Snickers candy bar, yes, you could make a Milky Way, and yes, you could make a Snickers. But if you have the ingredients and you have a Snickers, it does no good to say, and he also committed the other two. The other two would merge into that top one, and it would just be a sentence for the top crime. Now everyone's going to want some candy. Milky Way. I owe everybody chocolate. I don't know how I would distribute that. Tim, one time I did that demonstration with candy bars, and I showed I was taking bites out of all of them. I'd like to do that again, just because I'm hungry for Snickers. Are you saying we only need Snickers? Well, Snickers would be the greatest. In this case, there's going to be the as charged and at least one lesser included. Just took a bite of chocolate for that one. Self-addressed envelopes or candy bars. I could not do that. First of all, it would cost a lot of stickers, and I'm pretty sure the mail sorting machine would destroy every envelope. I do have one more. Becky, I got your letter. I'm sending a sticker out for you right now. I'll put it in while I remember. We'll get that one out to you. A check burner for Link to Canada. Thank you, Red Pen. All right. Oh, Cody, I saw the link. I'll check that in just a second. See if I can pull this up on this computer. Continue. All right, camera 3 is where it's going to be. All right, we're going to jump over really quickly. Red Pen has been keeping a thumbnail of the case, so to speak, and its developments. And just so this thumbnail, the reason it's built the way it is because in Jason Chen's apartment, he had a photo wall where he had a lot of pictures out posted on the wall. And what Red Pen has done is made a photo wall for details of this case. So we have a lot. We have handcuffs and shackles. We have Post-it notes. We have notepads. We have weed, THC. We have things I don't know. We have piles of evidence. We have a suitcase. We have Mr. Chen. We have my favorite witness who showed up originally in a Carhartt shirt and then later changed into a suit after lunch. We have all the receipts, the Leaning Tower of Pisa, which was reference to one of the ties, right? I think one of the ties the witness wore. We have the gentleman with the, oh my goodness, where did he come from? Was he one of the witnesses? I think he was one of the witnesses. We've got the Shroud of Turin on there. We have the Mama Bear detective. We've got the photo wall. We have a stabby picture. We have asparagus. We have a picture of the victim. Why do we have me? Why am I on there with the the little cross I'm wearing there? First of all, that cross I'm wearing is, I think it was worth like $12,000 just in gold and diamonds and sapphires if you melted them down, and it was picked up at a thrift shop for $3,000. And at the time I was wearing it, I was debating buying it from the lady who got it. I seriously regret not buying it. We've got the traffic cameras, rolls of bounty. Not sure what this one is. The Jason Chen's hat. Yeah, we've got basically a little bit of everything. Oh, here's the key. Look at the key. We've got the cough cannon, cuffs from Spencer's, Post-its, notebooks, wax and a blunt, witness wardrobe strategy. Number 1, wear all the things. Header experiment evidence box fort. Suitcase by the river, Jason Chen, witness wardrobe strategy. Change was a goat move. All the receipts, Leaning Tower is the tie on the medical examiner. Dr. Lewis, he was the one that was excluded. That's why we never saw him. But that's his picture from his website. The Shroud of Turin's there, Mama Sherlock. The wall, stabby with luminol. That's the blue. Asparagus, the victim. R.A. photos scientist. Mount Brawny. Swipe left fast. Oh, I did not know. I guess that's the Tinder app, the logo. I do not have that. I didn't know what the logo was. The Hennessy hat, reserved for verdict, and the RA watermark. There we go. All right, we have all those things. Great job, Red Pen. It's all there. It's all there. The reason I didn't buy that cross, well, there's 2 reasons. First of all, I didn't have $5,000. That's what she wanted to sell it to me for. And the second was there's concern that it was loot from the war. A lot of times when there's a war, soldiers might take mementos, and it could have been loot from a war. The origination of it was not secure. So if it had been stolen, if it was stolen, because it's called a pectoral cross, and it's extremely ornate. It has like cashmere sapphires or something in it, which were very rare and specific to a certain time period in a mining area. Diamonds, gold. It has gold filigree in it, which is specific to a time. It's got some markings in Europe, from Europe, to show the purity of the gold, 18 karat gold. Lots of things on there. If you took it to, say one of the big auction houses and tried to sell it, they would research it. And if they found where it came from and the person said, yeah, it was stolen from us, you lose it, they get it, and it's gone. So yeah, I didn't want to buy stolen merchandise. It was donated at a thrift shop. Somebody probably thought it was costume jewelry. It weighs a ton. It is so heavy. It's all legit. All right. I see the jury wanted to know the length of sentence each charge holds. They're going to want him to pay for what he did to her, says Stroll Life Creations. Dateline this past Friday was all on Melody Pearl's Ferris case. It was a good watch. I was hoping Keith Morrison would bring up the little man in the corner with Martha Jane. They cut that part out. They just used the part where she said that she, her conscience got the best of her and she made the call. But what time is court back? It will be back in about 5 minutes. I'm not worried about haunted. I've only got one ghost story that scared the daylights out of me, and I'll tell it some other time, but I've seen plenty of weird stuff that doesn't bother me. Let's see. No, they said she was live streaming the case, but didn't say where or what or how. That's too bad. It would have been cool if they called me and just even got my go ahead to use my name or something in their story. That's fine, but they didn't. They said a quick line about YouTube or watching online, but it was quick. Didn't mention RA. Amanda Florentine, taking you with me to work today. Happy Monday, everyone. Amanda, thanks for going to work where the rest of us are not. Well, I am, but everyone else, no. They said a live stream. That's the term they used. Why do you think they didn't go with the death penalty? Because it's difficult to prove a premeditation. That's why. Going through all our connections here. Yep. Okay. Sorry, I'm trying to merge all of my video sources together. Forgot today was national holiday, so I scheduled a normal workload, and now tomorrow is going to be rough for me, says Shark. I'm a teacher, so I have today off. I do believe your house is 100% haunted, but nothing aggressive or dangerous. Yep. You know what might be haunted? My shed. I've got a shed in the back corner of the property that I have never gone in. It scares me. But I'm scared because snakes and spiders and wasps live there. There could be a pirate's chest full of Blackbeard's treasure out there. I would never know. I would never know. I have not gone in it in the 6 years we've lived here. Holly Beck says, this is my work. This is what we're doing. I still think they need to see if she was his first or not. Kathy, I'm sure the investigators in the area have looked at that. But I'm not aware of anything in Tennessee that would indicate that that there was another. I saw a post on Facebook in my community that a neighbor near me has adopted a stray cat. And I'm like 99% sure it's my cat. Because my cat doesn't come around much anymore. And when he does, he's extremely well fed and has no interest in food. And he's all very playful and runs around, just comes up, gets pet a couple times, and then leaves. And and he's also, every time the door opens, he just expects to come inside. So I'm positive somebody has adopted the cat and let him inside. And now when he comes to our house, he just expects to go inside too. We actually had him get in the house the other day because the door opened a crack and he just shot in. So cat has like 3 owners now. Yeah, completely. He's got a heated cat house and all the cat scratch things, the toys, all on our front deck. The deck belongs to the cat now. He's got that. He's got his food bowls. He's got the cat fountain. He has all the things you guys sent for him out there, and he comes by occasionally and does a little bit. But I think he lives full time somewhere else now. Myron, the time to check out the shed is actually tomorrow, the coldest day of the year, because if there's any snakes in there, they're going to be too cold to bite me. If there's any wasps, they'll be too cold to fly and sting me. That would be the time. Cat's living a double life. We knew that from the get-go, that he had, that he was cheating on us. Occasionally we'll get into a little, a little battle with the other people who feed the cat and just try to outfeed the cat with better food to try to see if the cat will come to us first before he eats their food. To win that battle, I have to get like the top of the line brand name wet cat food. And that's the only way he'll come to us regularly. But other than that, he's got putting on plenty of weight, and he's got his ear docked, so the animal control definitely found him, and they catch and release. So he will not have any progeny. The ghost in the shed. All right, we're going to be coming back to court here in just a minute, so let's keep this right here. The only way to win back the cat is to give up the battle. The other family is she's a wonderful elderly lady that likes cats, and she's not moving anywhere. This is her home, so I don't want to go and say, "Hey, that's our cat." I mean, if she's taking care of him as well, I think it's wonderful. Cats, most pets have enough love in them for multiple people, so I'm good with that. Plus, it really is a benefit for us because I do travel occasionally for what we do, and the ability to be able to go and know that our cat is being cared for, that's good. That's a bonus. The ear clip happened over the summer. They in this area in our county they dock the left ear. They clip the top of the left ear. No, Melissa, I haven't heard anything else about the triple homicide. I believe he's in custody. Don't know. I think he's been arraigned, but I don't know beyond that what's happening. I've got to get with a lawyer friend of mine that practices in that courthouse and see if he has some scoop, because he likes to follow a lot of these cases. What's happening right now? We're just waiting for, actually, any moment now, we should be back in the courtroom. The defense is reviewing a motion the state just filed to exclude involuntary manslaughter as a lesser included, meaning we would not have any lesser includeds in this case. It would either be guilty of first-degree murder or not guilty. That's all the jury would be presented with. Clearly, defense does not like that. Their entire focus has been to get the jury to go for the lower charge, because that would, although he would be found guilty, they're fine with that. They admit that he is guilty. It would then give him a period of incarceration followed by a possibility of parole, which is what they want. Defense did rest this morning. Yes. No witnesses today. If there's a soft sit in Judge Simpson's court tomorrow, I think we definitely want to watch that. Why do they clip the left ear? So they can see from a distance that the cat has been sniffed. It's loud. We're back. Sort of. Pretty sure they're going to bring Mr. Chen, and then they're going to approach, and then we're going to be back. Jury is not present. Crystal, they called the dad to testify at the beginning of day 6, which was, let's see. Hold on. No. Take that back. Day 4.
I'm pretty just after looking at your respective motions, let those sides kind of know where I'm at the moment.
Day 6.
Feel free to argue accordingly. As far as voluntary manslaughter in general, again, the threshold
second witness
is not even a preponderance. I'm not saying this is even not even an arrestable thing. However, it seems like the evidence shows that the defendant and his case were in a relationship, that at the time this happened, there was some type of argument, there was a heat of passion, some type of heat of passion of some type, where, in a negative way, where there was an argument, a fight, based on what the neighbor downstairs reported. to the degree that there were footsteps. And so, again, while this would not be chargeable at all, the standard is taking the light most favorable to the defense. It seems that for voluntary manslaughter, that it should at least be charged. You can certainly argue that the elements do not satisfy that. At this point, that's where I am. Feel free to argue differently if you want to add to that. Mr. Weiss, I don't see any evidence of intoxication, other than the victim buying hemp, and the medical examiner's testimony was a little equivocal on that, but there was no, I don't recall any type of toxicology indicating any level of impairment on the victim. That's not even talking to the defendant, but that even substances were consumed that night. There might have been the wine bottle, but there's no evidence they were consumed that night. And as far as self-defense as well, I don't think that's been fairly raised at this point either, simply because, the deadly force that was used, the victim, the defendant would have to be shown to be in reasonable fear of his life to use deadly force. I don't think that's been raised at all. That's where I am, so feel free to, either side wants to start, you certainly can.
Spicy arguments here. Start with defense.
Your Honor, surprisingly, I concur with this court's thoughts regarding the voluntary manslaughter. I think the case law is pretty clear when a lesser included should be included in jury instructions. And I think it is fairly obvious here that there has been certain proof injuries. You heard the testimony from Courtney Brewer, Paglino, established an intensive emotional argument took place shortly before the incident. She had recalled hearing yelling and the sounds of people running. She heard a woman, specifically a woman, arguing emotionally, so we heard that.
Voluntary manslaughter at this point?
Yes, just voluntary. And as far as Dr. Cogswell is concerned, the court hit upon the injuries sustained by Ms. Pace were frenzied and erratic, committed in a way that's consistent with the heat of passion and excitement that corroborates the defendant's argument that he acted emotionally and overwhelmed and overreacted. There was proof of adequate provocation. It doesn't necessarily have to be a physical provocation. It can be an emotional or psychological. It can be just words. I think that Ms. Brewer also established that. Then there's the Tennessee courts have repeatedly held that voluntary manslaughter instructions are appropriate when there's evidence of adequate provocation and heat of passion. Cases of State v. Williams, State v. Eli. It's not the court's role to assess whether the defendant's serious case is credible, whether it is supported by any evidence in the record. Here, the combination of the eyewitness accounts, forensic testimony, the contextual evidence supports the inclusion of voluntary manslaughter.
Does the state want to argue anything beyond what's already argued?
Your Honor, again, the state understands the court's position. We disagree with it, and there's been holdings that by the Tennessee Supreme Court and Court of Appeals that, quote, it is true as a general rule that no provocation by words alone will reduce the crime of murder to that of manslaughter. So even if an argument is established, the state still doesn't believe that's enough for the record, but the state accepts and understands the court's analysis on voluntary manslaughter.
Okay. But based on what was presented in court, again, for the record, the court is not finding heat of passion to the degree that the jury needs to find it, but to the degree that it gets charged where it's less than preponderance, taking the light most favorable to the defense. I do think that the fact that the victim and the defendant were in a relationship, that they had an argument to the degree that it woke up a neighbor downstairs, was an argument that got physical, or I should take, there was definitely some footsteps involved during this particular passionate argument. So taking the light most favorable to the defense, I think we will charge voluntary manslaughter.
Your Honor, in regards to voluntary intoxication, the court will remember that when everyone entered into Jason's Chen apartment, we pointed out the volume on the desk. And so that was present throughout this entire case. That was well known. So we know that there were drugs in the apartment likely being used, or at least you can take that inference. In addition to that, there was the receipt by Ms. Pace that she had bought him that day. So there could also be an inference that when you buy hemp products, I would assume that you would buy them to use them. So it is a low threshold. There is no proof that Ms. Pace or the defendant was intoxicated at the time, but for the defendant, obviously there was no toxicology at the time. But for Ms. Pace, they did do toxicology, but because of an interfering substance, we don't know the THC content, if any, in this case as well. So that would give an inference that there was marijuana use. As far as wine, there has been talked about excessively. Open wine bottles that weren't finished, closed wine bottles. The court here heard about the glass. There was evidence that was introduced in the trial about the glass. I think that there is enough that raises enough about voluntary intoxication to include that as a jury instruction. You want me to?
Yeah, well, briefly, Judge, absolutely not. Because I have 40 bottles of wine and alcohol at my house right now does not mean that last night I was intoxicated. That's a silly argument. And there was no evidence of actual drugs in Mr. Chen's apartment. There was evidence of a bong. There was also evidence presented by multiple witnesses that the apartment had no smell of marijuana. The standard is not that you show that there was alcohol and a bong in a house. The standard would be that you show with sufficient proof that either party, but this would be arguing that Mr. Chen was intoxicated at the time of the offense. There has been absolutely zero proof of that. There was proof that the victim had no wine in her system at the time of the offense. Dr. Coswell testified that it should have still been in her system by the time the medical examiner's office took her blood, and cannabinoids actually had been tested and came back with a negative result according to Dr. Coswell. This does not meet the standard in any way, shape, or form of voluntary intoxication. In fact, under this argument, in every single case of murder where there was alcohol or a bong in a house, then we've got a good argument for voluntary intoxication. That's not the standard, Judge.
All right, on this one, the court doesn't find that there was evidence of any intoxication, by either party, much less by the defendant. So I think that as low as the standard is to charge voluntary intoxication, there's such a paucity of evidence in this particular situation, the court's not going to charge voluntary intoxication.
In regards to self-defense, so first I'm sorry with the opening, there is an argument that could have been made that the defendant acted in self-defense. The defense's theory, however, is that the defendant overreacted and reacted excessively, and so self-defense isn't proper in this case. However, it is the province of the jury to decide whether or not if that was self-defense. The jury could think that the defense is wrong and that he didn't have a duty to retreat. He didn't have, and he didn't overreact. They could, however unlikely, could think that. They could think the defense's theory is wrong. As far as the proof at trial, Dr. Cogswell talked about the contusion on the side of his face, which is corroborative of the defense's opening, that he kicked her and she fell back. It is indicative that the broken glass is also probative of that same incident where it falling back. We can see that something happens in the kitchen, living room area, but it ends up in the bedroom. How they get back there and all those different things, the proof that came into the trial could show, the proof that did come to the trial could lead a reasonable juror to believe that Mr. Chen was acting in self-defense at first and then overreacted as well.
State you want to go now.
Your Honor,
Wow.
the defense just said, quote, self-defense isn't proper in this case. pointing to opening statement, Mr. White is completely ignorant of the law in the state of Tennessee. And further, the idea that there's evidence that Mr. Chen kicked Ms. Pace is only evidence of further abuse. It is not evidence of any type of self-defense. And so the state, again, would ask that self-defense is a higher standard than voluntary manslaughter when it comes to adequate provocation. There has been no proof presented by the state or the defense that Mr. Chen could have or did act in self-defense. It is not deserving of an instruction.
All right, on this particular issue, what we do have is that the defendant, I believe, is 6'1", and large individual. The victim's size is barely 5 feet, around 100 pounds. The only evidence of anyone having a deadly weapon is the defendant. There's no evidence that the defendant was put in a reasonable state of fear where he could have believed that self-defense would have been justified. So I don't think that self-defense has been fairly raised by the proof the court has heard, so that the request for self-defense instruction be denied. Sure. Okay. It is 15 to 11. There's a couple ways we can do this. I'd like to go ahead and need to prepare these charges. I did, as the parties know, I did have self-defense voluntary provocation in there to what your day would bring. I need to tweak jury instructions. I'd like to go ahead and charge them. It'll probably take us to 11:40-ish, 11:50-ish, I would think. We can take a lunch break, come back and close at that point, or just go straight to closing after that.
Your Honor, the state would prefer that the court instruct the jury and then closing arguments be after lunch back to back. I would prefer that closing arguments not be split up. I don't think that's the best way to do it. And also in terms of jury instructions, there's a blank when it's the abuse of corpse instruction. There's a blank for that second prong that includes disposing of a body in a way that's in violation of Tennessee Code annotated and then it's blank. We would argue that that would be under TCA 39-14-505, which is aggravated criminal littering. It makes it aggravated if the littering, the matter of littering is over 10 pounds.
First time I had one of these, so that require a jury instruction on aggravated littering so they can find out who's in violation of it.
I think our jury instructions do contemplate the elements of the predicate offense to be instructed.
Okay. Well, let me tweak these instructions. We'll be in recess until that's done. I'm not sure when that'll be, hopefully next 15 or 20 minutes. I'll give the parties a copy before we bring up the... Okay.
Thank you, Judge.
Thank you. Thank you.
All right. So what we just got here is the judge goes back to do a little work in the back room to get the jury instructions. Yes, they did just talk about aggravated criminal littering. There's a charge that Mr. Chen's facing. I don't remember the exact wording related to disposing of the body and doing so illegally. And it's possible that they have a lesser included of aggravated criminal littering, and this is a crime in Tennessee if the item you are littering is over 10 pounds. They're talking about the body and the suitcase. So it sounds like a lesser included is aggravated criminal littering. Wow. I've only heard of littering being charged. That's a new one for me as well. So, what are the max for that is? It's probably a fine and up to 6 months in jail is my guess. It's just a fine. Yeah. Abuse of corpse is probably. I think abuse of corpse was the charge, although they did remove certain elements of that instruction, abuse of corpse, because there was no dismemberment and there was no essay involved, which are also areas where abuse of corpse can get involved. Okay, so the judge is now doing the homework. Just to summarize what just happened on those decisions, the state had made a motion to exclude the lesser included on the main charge, which was the murder charge. The lesser included would be involuntary manslaughter. Their motion was saying that's not appropriate because there was no evidence of an altercation, any instigation on the part of the victim, any of that. It shouldn't be allowed. The judge said there is evidence that there was an argument, a passionate argument, and he cited the scream and the running. I think the judge is wrong here, but I'm okay with his decision to allow that lesser included, but I think his rationale is wrong. If there is an attack where the victim has even a moment's notice that it's coming, you're probably going to get those same two elements. You're going to get a scream and running. Those two alone, I would say, are not an indication that there was a passionate argument involved. Yes, they were in a relationship, but just the fact that they were in a relationship does not mean that there was a passionate argument that preceded this. So I'm okay with that. I believe that had the judge ruled that it was improper to include that lesser included, I think that would be an area that would be looked at closely in an appeal. And so I think for that reason, for the reason of negating the chance at appeal, it was important to include it. But the rationale to get there that he cited seems a little generous there, beyond what I think the law allows or the law calls for. Okay. So you're checking the chat here. Just sent the link to Mod Chat about the law about aggravated littering in Tennessee. Let's see, I've also got a couple other texts here. Aggravated criminal littering can be a Class A misdemeanor or a Class E felony. The sentence depends on the amount of litter and the number of previous offenses. Class A misdemeanor, 10 pounds or more, up to $2,500 in fines, court costs, and up to 160 hours of public service. Commercially dumped is the same fine, up to 160 hours of public service. And then there's a Class C felony as well. Sent it in Mod Chat, you said? All right, criminal offenses, Title 39, litter control. Aggravated criminal littering is littering in an amount exceeding 10 pounds in weight or 15 cubic feet in volume in any amount for a commercial purpose, including knowingly placing, dropping, or throwing. Commercial doesn't apply, so I'll skip that. Part B, except as provided in subdivision B2, aggravated criminal littering is a Class A misdemeanor if the amount of litter exceeds 100 pounds in weight of 30 cubic feet in volume. Let's see. Then the defendant is subject to imprisonment provided by law, as provided by law, and a fine of not less than $2,500 nor more than $4,000. If it's a felony, Class C felony, if the third conviction, so he has to have two priors. It's a felony if the second conviction exceeded 1,000 pounds, or if the first conviction involves more than 8 tires that were placed, dropped, or thrown for commercial purpose. So it cannot be a felony in his case if they do cite him for aggravated criminal littering. And the maximum penalty he could face if the jury agrees that that's what happened would be $2,500 in fines and 160 hours of community service, which might be difficult to serve if he's also simultaneously serving life without parole. Community service is difficult to do in the jail, but I guess you could probably work something out. Mal's your pal. I enjoyed the weekend coverage. Surprised we don't see more sequestered juries for some of these high-profile cases. Well, not surprised, I guess. It's all about the money. Thank you, Mal's your pal, and congratulations on reaching that 11-month mark. That is wonderful. Appreciate your support. Eventually, this guy is lucky that he just didn't get the death penalty. I agree. I think some jurors would find for that if it was death penalty. missed this weekend. Did he take the stand? No, that was Valerie C. No. This morning is when we heard from him in the colloquy with the judge that he would not be taking the stand. And the reason cited by the attorney is that he would be facing some very aggressive cross-examination, and that could be very harmful to his case. So at least he knew the situation and made a knowing decision. Littering with a human corpse in the suitcase shouldn't be the same as littering with 100 pounds of encyclopedias in a suitcase. I agree. Mel, this sort of feels like, in a police chase when somebody's stolen a car at gunpoint and shot at cops while they're driving down the road and, sideswiped several vehicles, nearly hit some pedestrians in the crosswalk. And then they do get caught and face the judge. That they also say, and it looks like you were driving left of center. Your car had improper lane position. It seems like this is small potatoes compared to the big crimes that are out there. But yes, Karen, she does. I love it. I can always depend on her to cut my hair and me to be happy with it. Whereas when I go to some of the supercuts type of places, you never know what you're going to walk out with. So, Kimberlina, 15. One more month, my courthouse color changes. Woohoo! You're about to get that yellow courthouse. That'll be awesome. Thank you, Kimberlina. Breathing is important. It is. Also sent something else to Mod Chat that goes back in the archives. I was looking at that really quickly. Do you know how long it lasts? I need to know the amount of time the portion we're supposed to watch lasts. That's crucial for me to make a decision on that front. I can't even get it to play on my phone for some reason. Do you cut Mrs. R.A.'s hair? No, but I did cut my daughter's hair. We trimmed. She has long hair, and we trimmed about that much off. And I cut part of it. I cut some of the bottom. It was funny because I'd cut some hair off. I'm like, oops, and she would not think that was very funny when I'd say oops. I know the answer to this one. The truth is out there. It is 2 weeks. 2 weeks is the difference between a bad haircut and a good one. Haircut's ground zero. She got a really cool razor, like buzzer. What are they called? The hair clippers. She got a really cool set of those. They're all chrome and fancy. And I stole the smaller one because I use it as a beard trimmer for when I go too many days without shaving. My regular razor just doesn't cut it, my motorized razor, so I have to trim it down first. I stole that. It's beautiful. Love it. It's about 9 to 11. Like 2 hours or 10 minutes? Or is it 9 minutes and 11 seconds? I'm confused. Flowbee, anyone? We never had the Flowbee. I never had the vacuum that would work for that. I never got a bowl cut, and I never got the Flowbee cut. When the time when those were popular, I was getting my hair cut from a lady named Mrs. Thompson, and she was a neighbor who had a salon in her basement, and I would go over there, and she would talk with my mom for hours. The haircut took 10 minutes. They'd talk for hours, and she did a great job. She always told me I had like tons of thick hair. She's like, oh, so many people would be jealous of this. I'm like, I'm not. But now that mine is thinning, I'm like, well, now I am. What about the razor you found on your wall? We threw away the blade, and I have not yet thrown away the handle. Just watch it. Rosie's overruled. Welcome to the gallery. Congratulations on that second month of membership. 9 to 10 minutes total. That's the answer I'm looking for. All right. It's the first live that judge ever did. We'll take a look at that here in a minute. Michelle's Mixed Media Madness. Do send pictures. That sounds humorous. It's probably been long enough that he can laugh about it now. I've got a friend who cuts his own hair, and it looks great. I don't know how you can do that. I don't have the flexibility and the dexterity to trim the right length in places I cannot see. It's hard enough just to figure out, looking in a mirror, which way to move my hand to get the reflection to work right. I've had a 15-second haircut one time. I walked out of there looking like a hedgehog. You can go back to Saturday's stream. I don't know how long the judge is going to take here. So if we get an announcement of another break, we might watch that during the break. It's 11 o'clock. It sounds like we're probably going to get lunch before closings. We might watch it during the lunch break or coming back from lunch. What's wrong with the hedgehogs? Nothing. I just looked like one. Carol, it's definitely a possibility. As soon as the closings are done, we'll do a poll on how long we think the jury will take in deliberation. They'll have, I think they have about 4 hours, based on depends on how long closings are, but they'll have about 4 hours of deliberation time today. Valerie, no, there's parts of trial the jury just doesn't get involved in, and those have to happen. So I don't think it's a wasted time. The jury might wish that it was going faster because it's been a while where they have not seen their family. They've been gone for a week. My youngest son was the last one to cut his hair. I think he gave himself a reverse mohawk with the just skin deep. Zoop. The only thing you could do is shave his head at that point. Eileen, we did watch that high-speed chase with the dirt bikers on Thursday on the podcast. We covered that. Jerry wants to go home. Don't think the jury will need 4 hours. Tower Hill Girl, we're getting into this a little bit earlier in the day. We'll keep the audio on, so if anything happens in court, we're going to hear it. But the jury, from their questions and in their thoroughness in taking notes, I think it's very likely that they will want to look at some of the evidence that has been admitted that will be going back to them that they have not yet seen. Some of that is 300 pages of text messages. There may be some body cam footage that goes back that they might want to watch. There have been, I know there were promises of some stuff coming in through another witness that I don't think we got to, that was admitted evidence but has not been shown. So I think there might be some of them who want to be more thorough on this. So that could definitely lengthen that out and stretch a verdict into Tuesday at least. Folks need to be reminded about the definition of premeditated. It can be a matter of seconds, minutes, hours, days, or so on. In some states, they'll even say it could be formed in an instant. Amy Flo says, I cut my eyelashes off when I was little, not from both eyes, just one. The girl told me I wasn't supposed to have hair growing out of my eye. Worst advice ever. And I'm scared about how you cut them off. That is very dangerous. I think, yeah, I'm sure the jury all wants to see their family, their loved ones, their friends, but I think they're taking this seriously and they'll do their duty first and then go home. I don't think they're going to make a decision based on, I want this to be over. Krista, the way the lawyer described it in the opening, he blacked out during the attack and then came to and cleaned everything up. They might deliberate really, really late. That would be interesting if we have like a 10 p.m. verdict. We've seen late verdicts before, and if there's ever a chance that could happen, a sequestered jury is top. Now, they are not supposed to deliberate unless they're in the jury deliberation room. So it's not like they can go back to the hotel conference room and say, hey, let's keep this up. Let's keep talking. They need to deliberate when they're together in the jury deliberation room. We're just waiting right now for the judge to finish finalizing the jury instructions, which is the next step. The jury will be brought in. They will be charged, and the judge will take, I think it'll be probably 20 to 30 minutes to read all the instructions. These are important because we will hear in these instructions the possible penalties the jury will get to choose from. He may do this before or after the closings, but he may cover the verdict forms themselves and what the different options they have to select from. He'll cover the law, what the law is, what the elements of the charges are, and basically all the instructions that they have to use for their deliberation, as well as information about choosing a foreman and how they ask questions and what information will go back to them. This is a very high interest case. It got lots of exposure, and they're not worried about internationally and in other states. They're worried about locally, the area where you select the jury from, and it got a ton of interest. Yes, I like that. It lets her, it gives her response more punch. And I think she is going to be able to work it, because she works on the fly so well. I think her response to the defense closing, I'd love to see, first of all, I'd love to see DA Womp give that second bite at the apple for the prosecution. I think that's going to be fire. I think she's going to bring all the heat. And it will take all the air out of the defense's balloon. Yes, they do. All of the cables connected to my switcher are exactly the same. Well, mostly. They're all the same. They're actually a little white and red braided thin cable. Was there anything spicy during Saturday's court session? Yes, there was. There was a lot spicy. I would say the first half of the day is definitely a rewatch if you missed it. It was, we had surprise witnesses. By that I mean the witness was surprised that they were called. We had some fiery testimony and some exchanges, just some good work all around. And we also had some very interesting testimony from experts that were, I would say, questionable. Myron, yes, BK wants a public hearing now. He's changed his tune. They've been wanting it quiet. Now they want it public. Rose with Thorns, I have not. Once this case is over, maybe I can work on how many buttons I have, and we can figure out a way to do a contest for that and figure out what the prize is going to be. I actually have some samples of a merchandise item that are arriving, I think, tomorrow. Maybe we might do some prizes with that. Thanks for the link to Saturday's stream. That was a wonderful one, especially the morning. The afternoon is a little bit slow, but yeah, I would definitely suggest watching the morning for sure. Maybe skip through a little bit on the afternoon so you can see what happens. Michelle's Mixed Media Madness says, I rewatched the dad's testimony. What a low move on the defense's part. Yes. And then the dad immediately afterwards posted on, I'm not sure if it was Instagram or Facebook or what, posted a link. It's like, hey guys, look, I testified in court. He posted a link to him being in. So I don't think he was like gutted over it. But he sort of bragged about it a little bit afterwards. He did post online. So Kathy Trout says, I counted you have 1,240 buttons. You might not be wrong. I mean, I don't know. It's not a bad guess. It's not a bad guess, Kathy Trout. I haven't done the math, but you pushed 3 of them. Thank you for the likes. I appreciate those who are clicking the like button. That does help us out a great deal. We already have over 760 likes on the stream. It's at least half of you are somewhat happy with whatever I'm doing. So the other half of you, I apologize. I'm sorry that it's so miserable. Hopefully I can do something a little bit better in the future to help you like this stream. My prize could be a sticker. I'll send a self-addressed stamped envelope. I will send you a sticker if you send me an envelope. That's the deal. I have I have about 100 stickers left. As long as I have stickers, I can do that. When I run out of stickers, because they are expensive, I think that's as far as I can go. All right, still waiting for the judge to come back. The seal's a little bit out of focus this morning, so it looks not as crisp and clean as it normally does. And the longer this goes on, the more I think I should have started that video that Josh sent me so we could watch that, but now it's going to be too late. Well, you would have to send an envelope with enough U.S. postage to send it internationally for international stickers. But here's what I can do. You can buy a sticker pack through Sticker Mule, and I think they will ship internationally. So if you check out our Sticker Mule store, they come in 10 packs. You can buy stickers and magnets there. Welcome, Broken Bakers. Once again, another raid. Reverend Beasy, yes, I did. It is sitting in my wallet. Thank you. I appreciate that. That was quite generous of you. I appreciate that. I remember you asked for 3 stickers. I sent you 3 stickers. And the $10 bill to grease the wheels sure made things a little smoother. Greener says, I also sent a bill for $10. I missed that one, Greeners. Bakers, welcome. Thank you very much for popping in. We'd love to see the Baker raid. Joanne, welcome. Glad you got a moment to say hi here. How much is one sticker? I don't sell individual stickers, or Sticker Mule doesn't sell individual stickers. They're about $1 a piece to make. I don't get any special deal. So about $1 a piece. Did the likes put you over the 1,000 mark? We're at 836 likes right now. It did jump a little bit when the bakers came in. They're quite good at that. You guys are amazing. Thank you. Yeah, a big deal for sure. I've got a burner. Well, I've got a burner phone and I've got a PO box. And as long as I have stickers left, if you send me a self-addressed stamped envelope, I'll give you a free sticker. I'll cover the sticker cost. So I've sent out probably 100 or so free stickers. I've got one more envelope with a sticker to send out today, and I have about 100 free stickers left. So as long as that lasts, I can do that. But once the stickers are gone, I'm not sure if I can keep covering it. You love the map. If you want stickers direct or want a stack of them, a stack of stickers, there's the link right here. Yeah, there's the address. I check that a couple times a week. How much did the pirates sell corn for? About a buccaneer. Nice. Here we go.
I believe all the references to the defendant testifying taken out, references to the aspect we already talked about.
Your Honor, do you want to bring the defendant up?
Yes, absolutely. Thank you.
While they're bringing Mr. Chen out, we do have a map where if you would like to voluntarily share the general area where you're located, we can get you pinned. It is a world map. We have over almost 1,200 people on there. It's fun to see where people are watching from and how many people are in your area. We ask that you fill out the 2 links. The first link is where you submit your general location, not your exact address. We don't want anyone to dox themselves. On the second one, if you give it a little time after you've submitted that, your pin will show up on the map. Yes.
No, I didn't realize, this makes sense, but I didn't realize that, I guess reckless homicide comes after ag assault just because it's lesser. I didn't realize that.
Then the E felony of criminally negligent homicide is down there too.
Yeah, that's interesting. I've never noticed that.
They've got a whole bunch of lesser included.
Both sides are, if you want to go straight to the abuse of court, you certainly can. Again, I think the references to, again, the defendant testifying was the last thing I wasn't sure about. That was been modified to show that he hasn't testified and the jury can't hold anything against him for that. But once the parties finish reviewing it, probably do a proceeding for the jury.
So the 2 sides are now reading the instructions the judge provided. He's about to read to the jury. Where's the map link? There are 2 links here. The first link here on top, that's where you submit your information. And then the link on the bottom is where you can view all the different pins. And it does take a while after you submit your information for it to be
Your Honor,
posted.
the impeachment of a witness, I think there might be the beginning of a sentence that might have been deleted that's not all there.
What page are you looking at?
There's no page number, just impeachment of the witness. There's 3 paragraphs. The last paragraph, it starts off with impeach.
Hello, defense rests. Welcome. Today is your day because the defense did rest today.
When the testimony of the witness is impeached, the jury has the right to disregard.
Yes, sir.
Frosty Jen, if you send a self-addressed stamped envelope, I'll send you a sticker. If you want to buy a pack of stickers, I think they're a little around $1 each from the Sticker Mule link. And they ship straight from the factory.
There's also an instruction for a prior statement of defendant.
I kept that because wasn't there testimony about when Miss Pace, Katrina Pace, was talking to the police officers, they said that he gave statements that were...
There was also the written statements that were collected and no one's really done.
Okay.
That's a good one.
Okay.
As soon as they can come to an agreement on these instructions, the judge will bring the jury in and read them to the jury. There might be a little time to make copies for the jury and just correct any punctuation and stuff, but shouldn't take too long to do this little walkthrough. Ivan, congratulations on Bitcoin today. Wow, new high. Welcome from the Defense Rest. I didn't see the raid when it came through. I apologize if I missed it, but good to have you here. The reason the mics get shut off is the court has ordered that we're not supposed to be able to hear any discussion between the attorneys amongst themselves or between the two counsels. So every time they start whispering amongst themselves like that, we have to shut it off just for a minute.
Just go. Both sides ready to proceed? Bring the jury in when they're ready, please.
Both sides say the judge's copy looks good. We will bring in the jury. The judge will read them to the jury. The jury may actually have copies provided for them as well. Sometimes that happens. If not, there's going to be a copy that usually goes back with them to the jury room, because this will contain most of the instructions they need to perform their duty once they leave the courtroom and begin deliberations. I've only sent out autographs twice, and both times I signed a hoodie. I guess your autograph isn't very important anymore. My latest credit card that I got doesn't even have a spot to autograph. They don't use signatures anymore.
All right, please be seated. I'm about to read final jury instructions. Please pay attention. You don't have to write them down. You will all have a copy. There will be at least one, probably several copies back in the jury room as you deliberate. But pay attention, because the issues that are in these instructions do pertain to the issues that came up during trial. And so there may be one or two things that you see that you want to follow up with. And of course, the parties will follow up with them as well when they do their regular closings. Members of the jury, the evidence in this case has been completed. You will now be instructed as to the law applicable in the case. This covers your duties and the general rules that apply in every case. It also covers the offenses that are charged and included in the presentment and lists their elements. It includes some rules that you must use in evaluating particular testimony and evidence. Finally, it also includes the rules that you must follow during your deliberations in the jury room, and the possible verdicts that you may return.
Your Honor, I'm sorry. Are you intending for this to be scrolled?
Actually.
Didn't know. I apologize.
No. Thank you, Tim. It is your duty to carefully consider all these instructions. The order in which these instructions are given is no indication of their relative importance. Moreover, do not assume that because a particular instruction is given, it suggests anything about the facts of this case. You should not single out any one or more instructions to the exclusion of one or more others, but you should consider each instruction in light of and in harmony with the others. Count 1 of Presentment 315-228 charges the defendant, Jason Chen, with the offense of first-degree premeditated murder on or about November 23rd, 2022, in Hamilton County, Tennessee. This charge includes the following offenses: first-degree premeditated murder, second-degree murder, voluntary manslaughter, aggravated assault, reckless homicide, reckless aggravated assault, criminally negligent homicide, assault, and reckless endangerment.
Wow, all lesser included.
Count 2, Presentment 315-228, charges the defendant, Jason Chen, with the offense of abuse of a corpse on or about November 23rd, 2022, in Hamilton County, Tennessee. This charge includes the following offense: abuse of a corpse.
No lesser included there.
Presentment in this case is the formal written accusation charging the defendant with one or more crimes. It is not evidence and does not create any inference of guilt. To Presentment 315-228, the defendant, Jason Chen, pleads not guilty. The plea operates in law as a denial of every allegation of guilt contained in the presentment and every element of fact in the offenses charged in the presentment. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all the evidence in the case you determine beyond a reasonable doubt that the defendant is guilty of an offense charged or included in the presentment. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. This burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state has the burden of proving beyond a reasonable doubt all of the elements of the offense, and that the offense was committed before the presentment was found and returned on March 3rd, 2023. The state has the burden of proving by a preponderance of the evidence that an offense charged or included in the presentment was committed in Hamilton County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. The venue of an offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that an offense charged or included in the presentment was commenced or consummated in Hamilton County, Tennessee, you must return a verdict of not guilty. At times during the trial, the court has ruled upon the admissibility of evidence. Do not concern yourself with these rulings, either by such rulings, these instructions, or any other remarks that I've made. Do I mean to indicate any opinion as to the facts or as to what your verdict should be? Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in the case. You are also the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in the light of your own observations and experience in life. Any person who commits the offense of first-degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the victim, and 2, that the defendant acted intentionally, and 3, killing was premeditated. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. The design to kill was formed with premeditation. It is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion. The accused commits the act after the passion has subsided. Any person who commits second-degree murder is guilty of a crime. To find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, the defendant acted knowingly. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. In the context of this offense, the person acts knowingly when the person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. In the context of this offense, a person acts intentionally when the person acts with a conscious objective or desire to cause the death of the alleged victim. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. In the context of this offense, a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, a person acts knowingly when a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another, and 2, the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of circumstances surrounding or result of his or her conduct when the person is aware of the nature of the conduct, that the circumstances exist, so that the conduct is reasonably certain to cause the result. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. In the context of this offense, a person acts recklessly when the person is aware of, but consciously disregards, a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, a person acts knowingly when the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another, and 2, that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, a burn, disfigurement, and physical pain or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or the result of his or her conduct the person is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, that the conduct is reasonably certain to cause the result. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. A person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, the person acts knowingly when the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. In the context of this offense, the person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim or third party, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim or third party causing the death was a natural and probable result of the defendant's criminal negligence. Any person who commits the offense of assault is guilty of a crime. If you find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally, knowingly, or recklessly caused bodily injury to another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness, or the impairment of a function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, that the conduct is reasonably certain to cause the result. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or the result of his or her conduct, and the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Any person who commits the offense of reckless endangerment is guilty of a crime. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And 2, that the defendant acted recklessly. The threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or result of his or her conduct, and the person is aware of, but consciously disregards, a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, or that the conduct is reasonably certain to cause the result. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1A, that the defendant physically mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, or B, that the defendant disposed of a corpse in a manner known to be in violation of Tennessee Code Annotated 39-14-505, which defines the offense of aggravated criminal littering as littering in amount exceeding 10 pounds in weight or 15 cubic feet in volume, and that the defendant acted without legal privilege, and that the defendant acted knowingly. In deciding whether the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective, personal, and private views and evaluate the sensibilities of a hypothetical average adult person, applying the collective view of the adult community as a whole. Ordinary person means a person of ordinary care and diligence in relation to a particular thing. Littering means knowingly placing, dropping, or throwing litter on any public or private property without permission and not immediately removing it. Litter includes garbage, refuse, rubbish, and all other waste material.
We're almost done with these elements instructions.
Putrescible, animal, and vegetable waste resulting from the handling, preparation, cooking, and consumption of food. Refuse includes all putrescible and non-putrescible solid waste. Legal privilege means a particular or peculiar benefit or advantage created by law. A person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, the circumstances exist, that the conduct is reasonably certain to cause the result. The requirement of knowledge is also established if it is shown that the defendant acted intentionally. A person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result.
The jury is here. They're getting the instructions.
Before the defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was approximately caused by the criminal conduct of the defendant. The approximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to approximately cause the death, and in such a case, each of the participating acts or omissions is regarded as a proximate cause.
We're going to get a lunch break and then closings.
The negligent conduct of the deceased may also have been a proximate cause of the death. However, it is a defense to homicide if the proof shows that the death was caused by an independent intervening act or omission of the deceased, or another which the defendant, in the exercise of ordinary care, could not reasonably have anticipated is likely to happen. However, if, in the exercise of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of the death. It is not necessary that the sequence of events or the particular injury be foreseeable. It's only necessary that the death followed in the general field of danger, which the defendant should have reasonably anticipated. If some other circumstance caused the victim's death, unrelated to the defendant's actions, that would be a defense to homicide, unless the circumstance was the natural result of the defendant's act. If you find that the defendant's acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, you must find him not guilty. that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the charge or an included offense. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if, from the whole proof in the case, you are satisfied beyond a reasonable doubt that the defendant committed the charge or an included offense, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the charge or included offense, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or if you have a reasonable doubt as to whether he has been identified in the whole body of proof in the case, you should return a verdict of not guilty. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact of issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact of issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves.
Rosie, welcome to the gallery. Thank you very much.
It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything.
We've got a few more minutes.
You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness. It may help you to think about these questions. 1. Was the witness able to see or hear clearly? How long was the witness watching and listening? Was anything else going on that might have distracted the witness? 2. Did the witness seem to have a good memory? 3. How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions? 4. Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? 5. Does the witness have any bias, prejudice, or personal interest in how the case is decided? 6. Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? 7. In general, does the witness have any special reason to tell the truth or any special reason to lie? 8. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. You may conclude, however, that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. The testimony of a witness may be discredited or impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. The testimony of a witness may also be impeached by proving that he or she has made a prior inconsistent statement, that is, a material statement that he or she made out of court that is at variance with his or her testimony on the witness stand. However, the earlier statement is brought to your attention for the sole purpose of discrediting or casting doubt on the accuracy of the witness's present testimony here at the trial. You may not use the witness's earlier statement as proof that something said in it is true. When the testimony of a witness is impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. During the trial, you heard expert testimony. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact at issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it's up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. The court instructs you that while there is evidence of an oral or written statement given by the defendant in this case, you may take it into consideration with all the other facts and circumstances proven in the case. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe the statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given to such statement. If you decide the statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. If from the proof you find that the defendant has committed acts other than those for which he is on trial, you may not consider such evidence to prove his disposition to commit crimes such as those for which he is on trial. This evidence may only be considered by you for the limited purpose of determining whether it provides 1. The complete story of the crime. That is, such evidence may be considered by you where the prior acts and the present alleged crime are logically related or connected or are part of the same transaction, so that proof of the other tends or is necessary to prove the one charged or is necessary for a complete account thereof. 2. A scheme or plan. That is, such evidence may be considered by you if it tends to establish that the defendant engaged in a common scheme or plan for the commission of 2 or more crimes so related to each other that proof of one tends to establish the other. 3. The defendant's intent. That is, such evidence may be considered by you if it tends to establish that the defendant actually intended to commit the crime with which he is presently charged. Guilty knowledge. That is, such evidence may be considered by you where Guilty knowledge is an essential element of the crime charge, and evidence of the other acts tend to establish that the defendant possessed this knowledge at the time of the commission of the crime presently charged. Such evidence of other acts, if considered by you for any purpose, must not be considered for any purpose other than that specifically stated. The state has a duty to gather, preserve, and produce at trial evidence that may possess exculpatory value. Such evidence must be of such a nature that the defendant would be unable to obtain comparable evidence through reasonably available means. The state has no duty to gather or indefinitely preserve evidence considered by a qualified person to have no exculpatory value, so that as yet unknown defendant may later examine the evidence. If, after considering all the proof, you find that the state failed to gather or preserve evidence, the contents or qualities of which are at issue, and the production of which would more probably than not be of benefit to the defendant, you may infer that the absent evidence would be favorable to the defendant. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be a hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving of the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts known to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the way to be given to it are questions for you to determine. Any attempt by a person to conceal evidence is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Whether the evidence presented proves beyond a reasonable doubt that the defendant concealed evidence is a question for your determination.
Nanny, welcome.
If this fact is proven,
thank you so much.
It alone does not allow you to find the defendant is guilty of the crime alleged. A person entirely innocent of a particular crime may attempt to conceal evidence, and the concealment may be explained by proof offered or by the facts and circumstances of the case. However, because an attempt by a defendant to conceal evidence may be caused by a consciousness of guilt, you may consider this fact, if it is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. It is for you to determine whether there was any attempt to conceal evidence by the defendant, the reasons for it, and the weight to be given it. The court has charged the jury concerning an inference the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence, or both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanations along with all the evidence to determine not only the correctness of the inference, but also to the reasonableness of the defendant's explanation. You are not bound to accept either the inference or the defendant's explanation. The state must prove beyond a reasonable
not
doubt
that bad,
every
guys.
element of the
It's not
offense
that
before
bad.
the defendant can be found guilty. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take a stand in his own behalf. His election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. During your deliberations, you must not communicate with or provide any information to anyone about this case by any means outside the jury deliberation room. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter,
TikTok.
or any other social media to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. During this trial, you have been permitted to take notes for your own use during your deliberations. The notes you may have taken should not be considered to be a transcript of the testimony. As such, once you retire to the jury room, you may refer to your notes, but only to refresh your own memory. You may not read from your notes to your fellow jurors or otherwise inform them of what you have written. The notes may contain errors. They may be understood or taken out of context, since they could only pertain to part of the testimony and are not an exact account of what was said by the witness. You are free to discuss the testimony of the witnesses with your fellow jurors, but each juror must rely on his or her own memory as to what a witness did or did not say. Upon conclusion of your deliberations, the court will collect and destroy all of the notes taken by any juror.
We're near the end.
Count one of the presentment includes, in addition to the charged offense, one or more lesser offenses. The offenses are listed in order from greatest to least. In reaching your verdict on count one of the presentment, you shall first consider the offense charged in the count. If you unanimously find the defendant guilty of the charged offense beyond reasonable doubt, you shall return a verdict of guilty for the charged offense. If you unanimously find the defendant not guilty of the charged offense, or have a reasonable doubt of the defendant's guilt of the charged offense, you shall then proceed to consider whether or not the defendant is guilty of the next listed offense. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or if you unanimously have a reasonable doubt the defendant's guilt of the immediately preceding greater offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in count one, you shall return a verdict of not guilty on that count. The crime charged in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty on one or both counts. Your finding as to each count must be stated in your verdict.
TikTok is up right now.
The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so while respecting individual judgment. Each of you must decide the case for yourself. Do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. Do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations and ensure that they are conducted in a business-like way and everyone has a fair chance to be heard. When you have reached a verdict, you will return with it to this courtroom and your foreperson will deliver the verdict forms to the court. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. If, however, you find that the state has not proven the defendant's guilty beyond a reasonable doubt, or if you have a reasonable doubt as to the defendant's guilty, then you must find him not guilty. You will be provided with forms of all possible verdicts in this case. The jury will complete the forms, and your foreperson will sign and date them. The verdict forms that you will receive read as follows. With respect to count 1, Presentment 315228, we, the jury, find the defendant, Jason Chen, please mark one of the following verdicts: guilty of first-degree murder, guilty of first-degree premeditated murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of aggravated assault, or guilty of reckless homicide, or guilty of reckless aggravated assault, or guilty of criminally negligent homicide, or guilty of assault, or guilty of reckless endangerment, or not guilty. With respect to count 2 of Presentment 315228, we, the jury, find the defendant Jason Chen, please mark one of the following verdicts: guilty of abuse of a corpse, or not guilty. Members of the jury, you have heard and seen all the evidence in the case. After lunch, parties will have the opportunity to present their closing arguments. Under the rules of criminal procedure, the state will argue first, and the defendant will have an opportunity to present his closing argument. The state may then, if it chooses, argue in response or in rebuttal to the defendant's argument. Closing arguments are designed to present to you the parties' theories about what the evidence has shown and what conclusions may be drawn from the evidence. Remember, what is said in closing arguments is not evidence. You've already heard and seen all the evidence in this case that you may properly consider. During their closing arguments, the parties may mention points of law or refer to these instructions that the court has given you. However, the law that you must follow in reaching your verdict is the law that the court has given to you in these final instructions. If there's any difference between what the parties say about the law, what this court has said in these final instructions, you must follow the court's instructions.
Wow.
Ladies and gentlemen, those instructions, it is 12:20. Terry, can you break it home, please? Yes, sir.
Next instruction is to go to lunch. We made it through the instruction. They were not that bad. It took less than an hour. It took much longer on like Darrell Brooks, right? Of course, he had like 99 charges. But.
You're going off campus, so we're going to take an hour and a half lunch. So I'll give you time to have lunch. Be prepared. Schooling arguments will probably lengthy. It's 12:20, so parties and jury be back here at 10 minutes to 2.
What time did you say we come back? $150. Okay, I'll change it. We've already got a portal set up.
Any of the party needs to bring up before we take our lunch recess?
No, you're fine.
After the reading of the jury instructions, it's not so much an objection, it's just a question for the court. Do you perceive there to be an issue with the use of performance instructions? Because, well, first off, I'm not sure if that's any but if it's not a continuing offense, then the state would be required to make an election of offenses. So I've never encountered that situation before. I've researched this slightly. I don't know.
You see that basically the state has alleged a series of abuse of corpse, one that was treated in a manner that offended the sensibilities of an ordinary person, and two, that it was in violation of a law.
If he's found guilty of that offense, we won't know of which one.
Generally, got a response to that.
No, Your Honor, I'm actually not sure under this statute whether election is required. If the court wants to play it safe and require that the jury pick one or the other, that's the safest route to go, but I haven't looked up, the jury instruction says or, so we can research it, but I'm also for appellate review purposes fine with requiring the jury to choose which one.
I do know that we've given it to juries, like aggravated burglary cases, for example. Felony theft or assault is an indictment that's been found to be fine. So I don't think there's no problem so far. To be safe, I may add in that final form or use of a corpse one or two theories, but I have to check one or the other.
You could do that. It also makes me think of aggravated assault. We are not required to elect under which category of aggravated assault, so I'm not sure if it's analogous or not, but we're not required to elect it. Can I?
Fine so far. Just whether or not
sure
the jury instruction should be tweaked.
Aggravated assault, I think, is a continuing offense. I don't know if a use of force is. I guess it could be, but
based on the littering component of it, of course, I think it probably lends itself to the fact that it might be. Right? The litters.
I never considered the issue.
Okay, let's do this then. Do one more thing I get to look at over lunch. You guys enjoy lunch. I'll get ready for your closing, I should say, and I'll let you know what I find. Okay.
Thank you, Judge.
Thank you. 150.
All right, they're going to go to recess till 1:50. I'm not understanding exactly what he's saying about the charges. We'll have to hear. The judge is looking at it. It's like a weird elect one or the other option. But the reason why those took so long was that there are a ton. I thought there was just one lesser included. There are a ton. The main charge is first-degree premeditated murder. Underneath that charge, we talked about Snickers, right? And if you take away one element, you get all these lesser charges. The lesser charges are, first, there's first-degree premeditated murder. Then second-degree murder is just under that. Voluntary manslaughter, aggravated assault, reckless homicide, reckless aggravated assault, criminally negligent homicide, assault, and reckless endangerment. So he's going to be found guilty. And I'm going to just go out on a limb here and say it's going to be one of the top ones. It's probably going to be first-degree premeditated murder or second-degree murder. Voluntary manslaughter in a stretch. But all those lower charges, the judge had to read every single element of every single charge for the lessers as well. That's why it stretched so long. Did I say manslaughter? We'll need more candy bars for sure. Well, I'll take a Snickers, Sophia. Let's go to the top one. I'll take a Snickers. All right. Here's what we're going to do. We're going to come back and watch. The little bit that Josh found for us. It's an older trial from a while back. It's the first time the judge ever streamed online. That was a lot to read for anybody. It's all technical as well. It's no fun story time. Anyone who's reading jury instructions, but we got through them. The jury has those instructions. I think they're good. I think they're ready to begin. When we come back, we will have closing arguments, which will be fire. They're going to be really good. They're going to. I don't know if we're going to get both Cody Womp as well as Mr. What's his name? Paul Moyles. If we get one and then the other, they're going to bifurcate and do it that way. Or if we get Cody on the part one and part two, I really hope that we get Cody Womp, DA Womp, on the closing on part two for the state. I'm pretty sure we're going to have Mr. Wise for defense and not Amanda Morrison, but we'll see. All right, the music. Please play the music. There's the music. We're going to go to lunch. We're going to be back. It is 12:25. I think we'll be back around in about an hour. I know I put the timer for 1:45. I think we'll be back before then. Big thank you for everybody who helped us reach 1,000 likes on the stream. We're now well over that, 1,035. We get closings today, and yes, there's a chance we have a verdict. We will definitely be in verdict watch before the end of the day. There's a chance the jury returns a verdict very quickly. Remember, they have not discussed this with each other yet. They don't know. They might walk into that jury room, look at each other, and do a quick straw poll and say, "Yeah, we're done." So that'll be interesting. Food time is always a good time. Yes, it is, Katia. It does appear that Travis Pace sent out an inadvertent text on his, or post on his Facebook, where he said that the jury had returned with a verdict. I think he was prepping that as what might be funny. He sent it out. He's since deleted it, but obviously the jury has not even started deliberations. So if that's accurate, it's not. Yeah, it's gone. It's gone now. A lot of choices. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. In about 1 hour from now, we will have closing arguments in the Tennessee versus Chen case. It's going to be fire. It's going to be a little more heated chess match there in the courtroom. I'm here for it. We'll see you guys in a little bit. Bye-bye. Incoming portal.